All right, welcome to another day of the Joint Corporations, Elections, and Political Subdivisions Committee. We are meeting for the last time of the interim for these next 2 days. We have a pretty aggressive agenda in terms of the number of bills that we're going to pass through, and we're going to take them all one by one. So if you're here to make testimony on bills, just know that's the strategy for the next 2 days. And with that, Mr. Co-Chairman, do you have any opening remarks before we call the roll?
No, I don't. Go ahead.
All right, let's call the roll.
Good morning, Mr. Chairman. This is roll call for October 26th, 2023. Senator Barlow?
Here.
Senator Boner? Senator Landon? Senator Scott?
Yeah.
Representative Chadwick? Representative Harrelson?
Here.
Representative Harshman?
Here.
Representative Knapp?
Here.
Representative Newsom? Here. Representative Ottman? Here. Representative Wiley?
Here.
Representative Yin?
Here.
Co-Chairman Case?
Present.
Co-Chairman Olson?
Here.
We have a quorum.
All right. And with that, we are 7 minutes ahead of schedule as we see how that worked. We built the agenda just in the right way. All right, elections. LSO, do you have something broad to present to us? I guess I'm confused by the agenda. It just says LSO. Okay, all right. All right, let's take the bills and go through them one by one, and then we'll take testimony on them. So the first bill is 24 LSO 0091. Voter qualifications durational residency requirement. See, I did half your job because I read the title for you.
Thank you, Mr. Chairman. Luke Plum, LSO. Yes, here to discuss 24 LSO-0091. This is a bill we saw at the last meeting. There were just a couple changes that were made to the bill. First off, the effective date has been changed to be immediate. And then the second one was to discuss, it was a conceptual amendment to change the language to require that in order to be a qualified elector, a person has to have been a bona fide resident of Wyoming for not less than 30 days before the date of the election at which he offers to vote. And I just wanted to, I kind of meant to bracket that a little bit. I just wanted to provide some information and some of the reasoning behind including the language of the election. It's before the date of the election at which he offers to vote. Because I understood, the conceptual amendment was, the language that was kind of offered was 30 days before the date at which he offers to vote. And so there were a couple of reasons that I included in those 3 extra words of the election. And really, yeah, it's not wrong or right, just something I thought that I'd bring to the committee's attention as we've been discussing this throughout the interim. But so the big thing would be that if the committee were to desire to change it so that it would just say 30 days before the date at which he offers to vote in order to be qualified, throughout the bill it'd be very easy to remove that language of the election. But the reason it was inserted was mostly because in the U.S. Supreme Court in their Dunn v. Blumstein decision, they had said that when they decided that the max that a durational residency requirement could be was 30 days, is that 30 days appears to be an ample period of time for the state to complete whatever administrative tasks are necessary to prevent fraud, and anything over that too much. And so really what this does is if you were to say before the date of the election at which he offers to vote, I think that just provides a date certain to establish 30 days. It's a 30-day period that that the person who is going to vote has been a Wyoming resident. And so then you can definitively say, for the purposes of, clerks running, clerks and administrative staff running the elections, they can say you have to have been 30 days before. And then also for any challenges, which would be the, which would be the primary way that this would be enforced, is if there was a challenge to it. And so really it's just those kind of options. Once again, just I think, the scenario I was foreseeing just may be, if a person does offer to vote early, say a week ahead of the actual date of the election, then if you say before the date at which he offers to vote, that could be, maybe considered 30 days before an election, just in consideration of that done decision. It would be that 30 days plus that additional time. I don't know if that really would be a problem. Some of the other states' language is not consistent. Colorado is 22 days immediately prior to the election in which the person intends to vote. Idaho has resided in this state in the county for 30 days, where he or she offers to vote prior to the day of the election. South Dakota is, you have to have been a resident of the state within 30 days prior to submitting your registration form. And Montana just says you have to have been a resident of the state and of the county in which you offer to vote for at least 30 days. So the language is very broad there. But I drafted it in a way for making this amendment to, if of the election at which he offers to vote, or you can just remove that throughout the bill. And the oath could also be similarly changed on page 4, just to say something similar to, it'd be removing the of the election language and inserting that I offer to vote, such that it would say I resided in the state for not less than 30 days before the date that or at which I offer to vote. But throughout, it would just be throughout the bill, the changes have been made that you have to have been a resident of Wyoming for not less than 30 days before the date of the election at which he offers to vote. So with that, I'd stand for any questions.
Representative Newsom?
Thank you, Mr. Chairman. So as I get this straight in my brain, so let's say election day is November 7th. October 7th would be 30 days prior. So if somebody is a resident on October 7th or before, then they would be eligible. But if they decided to vote on October 13th, they would be eligible to vote because they've met that requirement of 30 days prior. If they were a resident on October 7th and they decided to vote on October 13th in a November election, that would be all straight up legal.
Mr. Plum?
Mr. Chairman. Representative Newsom, I think that is a great question and a great way to say it, yes. And I think that's why, once again, it was kind of drafted where, you could remove that of the election language, because that is a consideration, right? If you did move here on the 6th, and so that you were, going to be definitely within your 30 days because the date of the election, but you could vote early, reasonably could, and be able to, but you would be a resident at the 30-day mark of the election. But so that's just the question, is if you back it up to when they actually vote. Mm-hmm.
Senator Scott?
Yeah, Mr. Chairman, the following up on that, suppose you have a circumstance exactly as Representative Newsom was describing, and you go take the oath, and the way it's worded, if you look at page 3, line 19, has been a bona fide resident of Wyoming for not less than 30 days before the election. That's kind of awkward. You're asking somebody to say that he has been 30 days before the election. You're implying you're going to still be on the election. It has been is kind of awkward. My question is, would we fix that by simply saying, after he says after on line 19 on page 3, he has been or will be at the time of the election, just add those words in, because I think the current version is a little confusing with the new language that's in there now.
Mr. Plum?
Mr. Chairman, Senator Scott, I think that is a very fair point, right? It would just be a matter of application, and to clarify in the statute, I think that definitely could work to say has been or will be a bona fide resident of Wyoming for not less than 30 days before the date of the election. Like those two, if you tie those two together.
Mr. Plum, in the LSO staff comment, you also cite to the Federal Voting Rights Act. And we talked about this in our first meeting, that no one can be denied the right to vote for president based on durational residency requirement. My question for you is legally, that federal statute's going to apply no matter what we do. Is there a benefit to putting in this statute that clarifying that in this statute? Is there any benefit at all to doing that, or are we okay just because it's a federal law and it's going to apply no matter what? 'Cause I wasn't really sure, based on your comment, if you wanted us to include something or not.
Mr. Chairman, that's a really good question. And yeah, and that was even kind of the purpose of the comment, right? It was that there's not really a clear answer to that question necessarily. I think there is perhaps some value to specify just so that there isn't any issue, but in my research, it was not, most states do not have like the Wisconsin example. I was not finding those in statute. Just states have to comply with the Federal Voting Rights Act. And so to be silent on it is just still that you would still have to require, state would still be required to allow people to vote for president and vice president. It's just whether, you want to clarify that and make it known in Wyoming statute. It's really up to the committee's consideration.
Mr. Chairman.
Mr. Co-Chairman.
Well, I would hope that we would clarify that in the sense that, our laws should be accessible to anybody, and they shouldn't have to know that the double meaning or the except for, they should be able to just read it. And so if a new resident were to come to Wyoming and they wanted to vote in a presidential election, which they would be up on, they'd certainly be qualified, that's something of interest, but they looked in our law, they may be discouraged from voting in that election if it's not clear. So I would hope we would make it explicit.
Yeah, Mr. Co-Chairman, I tend to agree, which as well, that if a layman were to pick up the statute, they wouldn't know. But even just for moving this bill through the chambers, I think it will be easier as well, because that conversation is likely to arise at some point in time, and then we have to explain that a federal statute applies when it could just simply be in the bill. So I agree. Other questions for Mr. Plum, committee? Representative Ottman.
Thank you, Mr. Chairman, Mr. Plum. On these, what I'm wondering is that Colorado and some other of these states have state as well as county. And so what I was wondering was, say someone was a resident of Rock Springs and they came up, if they were in Rock Springs, say for 30 days because they were part of the state, then could they come up to another county and vote for like commissioners or special districts or anything? Do we need to put county in there as well?
Mr. Plum?
Mr. Chairman, Representative Ottman, really that would be up to the committee's consideration. I think, under this bill, if you had lived in Rock Springs for 30 days and then you go and you register the day before an election in a different county, reasonably you'd be allowed to vote on that ballot. I think underneath this. And so, yes, it is not uncommon for other states to also include county. That would just be up for the committee's consideration.
All right, thank you, Mr. Plum. Move to our Secretary of State's office. Welcome, Mr. Secretary.
Thank you, Mr. Chairman. For the record, I'm Chuck Gray, the Wyoming Secretary of State. I'm joined to my right by Joe Rubino, our Policy Director and Counsel. I'm in complete and total support of imposing a durational residency requirement to vote in Wyoming, and appreciate the committee agreeing to take up our request seriously that this needs to be taken up. At present, Wyoming remains one of a minority of states without some sort of durational residency requirement. And effectuating appropriate requirements like a residency requirement help to ensure integrity in our elections by making sure Wyomingites and only Wyomingites are voting in our elections. I wanted to note a few things concerning the bill in its current form, as well as the work our office has been doing concerning residency requirements. Again, I am in complete and total support of a durational residency requirement. I do want to be clear that I would like it to be stronger than 30 days. But right now we have nothing, and 30 days is what is clearly going to survive constitutional scrutiny. I believe it is essential to ensure that Wyoming has safeguards in place to strengthen Wyoming's residency requirement and ensure that there is a durational aspect to ensure Wyoming's elections are decided by Wyomingites. As to the LSO staff comments, our office has previously analyzed the language of the bill as it is largely modeled after Idaho, which is also exempt from the National Voter Registration Act. For the reasons we already set forth during the August Corporations Committee meeting, I believe it fits squarely in line with constitutional requirements. And I think we need to review a little bit, like to go through again the federal law situation and the Voting Rights Act. It's very important to note 52 USC 10502E, which provides that voting in person or by absentee ballot in state of prior residence, if any citizen of the United States who is otherwise qualified to vote in any state or political subdivision in any election for president and vice president has begun residence in such state or political subdivision after the 30th day next preceding such election, and for that reason does not satisfy the registration requirements of such state or political subdivision, he shall be allowed to vote for the choice of electors for president and vice president or for president and vice president in such election, one, in person in the state or political subdivision in which he resided immediately prior to his removal, if he had satisfied as of the date of his change of residence the requirements to vote in that state or political subdivision, or by absentee ballot in the state or political subdivision in which he resided immediately prior to his removal, if he satisfies, but for his non-resident status and the reason for his absence, the requirements for absentee voting in that state or political subdivision. In other words, the statute makes clear that they can vote in their previous state of residence if they do not meet the registration requirements in that state, and it fully contemplates a 30-day durational residency requirement. I also alert you to Justice Stewart's concurrence in Oregon v. Mitchell, which states that Section 202 added by the Voting Rights Act amendments of 1970 is a comprehensive provision aimed at ensuring that a citizen will not be deprived of the opportunity to vote for the offices of president and vice president because of a change of residence. Those who take up a new residence more than 30 days before a presidential election are guaranteed the right to register and vote in the state to which they have moved, notwithstanding any durational residency requirement imposed by state law, provided, of course, that they are otherwise qualified to vote. Those who take up a new residence less than 30 days before a presidential election are guaranteed the right to vote either in person or by absentee ballot in the state from which they have moved, provided that they satisfied as of the date of their change of residence the requirements to vote in that state. So again, that concurrence backs up that it is in line with federal law that they would be allowed to vote in their previous state of residence if they did not satisfy the durational residency requirement. I also want to address some comments by the County Clerks Association. I'm in complete and total agreement with the county clerks that strengthening the definition of a bona fide resident is necessary to ensure the integrity and security of Wyoming elections. And I do believe this lack of clarity exists regardless of any changes to a durational component of residency. For example, right now, Wyoming statute still requires that to be a qualified elector, a person must be first and foremost a bona fide resident of Wyoming. And this does not change with any durational aspect. However, considering the county clerk's comments following the Joint Corporations Committee meeting in Douglas and in consultation with the Legislative Committee of the County Clerks Association, our office began work on amendments to Chapter 2 of the Secretary of State's office's rules governing election procedures as they relate to providing proof of identification for voter registration. The proposed amendments will require not only proof of identity to register to vote, but also proof of residency to register to vote. This will help aid election administrators by providing clarity in determining when someone is a bona fide resident of Wyoming when they register to vote in accordance with 22-2-121. These rules are nearing completion, and I anticipate we will go out for public comment in early November, and I've really appreciated working with the County Clerks Association with that. Now I want to briefly go into the latest amendment to the draft bill, which is based on Senator Boner's conceptual amendment. While the amendment further clarifies that the 30-day residency requirement would be from the date of the election, in other words, election day, I am not sure this matches the intent of the conceptual amendment originally brought by Senator Boner, and I think we saw Mr. Plum acknowledge that. As I understood Senator Boner's amendment, the 30-day requirement would be from the date at which a qualified elector offers to vote. This could be on election day or by absentee prior to the election. However, requiring that a qualified elector must have resided in Wyoming not less than 30 days before the date of the election will not be treated as the date the qualified elector offers to vote. Our office reached out to LSO prior to this meeting, and we discussed the intent of the amendment as well as the constitutional limitations set forth and interpreted by the U.S. Supreme Court and the Wyoming Supreme Court. And I want to be clear here again, I think in light of those limitations, that's some of the problem with the Senator Boner conceptual amendment. And again, while I'd like something stronger, we really do need to get something on the books. This is a huge hole in our statute. While as a matter of policy, I would certainly support a policy requiring the 30-day requirement be from the day the individual casts his or her ballot. The draft language and the amendment is currently drafted are grappling with some of these constitutional issues, and did check what other states do, and it largely is, it is 30 days from the date of the election. So I think that that's in line with the current language. Again, I stand in total support of Wyoming, of a durational residency requirement for voting in Wyoming. Thank you.
Representative Yin.
Yes.
Thank you, Mr. Chairman. Mr. Secretary, since you're going to be the administrator of election code, if this bill passes, do you have any thoughts on what makes a bona fide resident? Because Teton County and I know other communities have folks that live a lot of the time in a different state. So if they're gone during several months, possibly in the winter, how would you define a bona fide resident?
Secretary Gray.
Mr. Chairman, beefing up the definition of a bona fide resident, I think is another step in this process. But I think it's going to be very difficult no matter what to keep it outside of intent, which could be any duration. And that's why you need a durational residency requirement. And that's the problem. I mean, I go back to when this was identified. I had a Zoom call with the county clerks in 2020, late 2020, as we were prepping the voter ID bill. And we started talking about a few other issues. And I started talking about durational residency. I asked them, if someone claimed they were a bona fide resident for 15 seconds, would it be prosecutable? And I was really disturbed that the answer appears to be no. And I don't say that with any pride, but we need to be clear on where we're at in light of the 72, 73 decisions done in Del Giorno and the lack of action by the legislature since then. That's why we need this. Now, outside of the bona fide question, you have the question of being able to register and the documents to prove residency. And that's, again, going back to our testimony, in light of the clerk's testimony in August, we started working with them on our registration requirements and are looking forward to beefing that up. But that's outside of the bona fide question. So appreciate that. And I continue to think beefing up that definition, I'd be fine with that. But it's going to be difficult, I think, to take it out of intent. And that's why you need the durational aspect, because intent is ultimately, someone could claim intent after 30 seconds and say they're here, they intended to stay, and they interviewed for a job in the newspaper and they intended to stay. So it's a challenging one. And that's why you need that durational aspect. I do think the registration rule and some of our revisions would be a protection in that situation. And I think in concert with the durational changes is another strengthening.
Representative Newsom.
Yes.
Thank you, Mr. Chairman. Where in statute is bona fide resident defined? I don't see it in this particular bill, and I'm wondering where that's defined in statute.
Yeah, Mr. Chairman, I'm going to go ahead and turn this over to council.
Mr. Rubino.
Mr. Chairman, Representative Newsom. So the definition section of Wyoming Statute 22-102, subsection A, Romanet 30 defines residence. And so it goes through, this is typical of state statutes, going through sort of principles in determining residence. Romanet 30 provides residence is the place of a person's actual habitation. The construction of this term shall be governed by the following rules. And then, as the secretary was just mentioning, the first rule, capital A, residence is the place where a person has a current habitation and to which, whenever he is absent, he has the intention of returning. it also goes into some of the things that we've gone through in previous joint corporations committee meetings, such as moving to another state, you're still allowed to vote in Wyoming if you don't meet the residency requirements of that state. Thank you.
Follow up, Representative Newsom?
So I think I asked this in Douglas. So if a person requesting to vote comes to the county clerks, what documentation do they need to bring? Should this pass? What documentation do they need to bring to assure that our county clerks that they are a bona fide resident?
Secretary Gray?
Mr. Chairman, and again, this is an attestation. It is an oath aligning with this requirement in state statute. The registration requirements, which we're working on strengthening with the county clerks, is a separate question. And that's all of the documentation that is required to register to vote. It's an attestation, so it's an oath. Yes.
But it's an oath, but you could require by rule, couldn't you require certain things to be proved when they do make that attestation, so they could bring a utility bill or something? Have you given thought to exactly what you want that to look like?
Mr. Chairman, absolutely. And that's what we're doing with the county clerks right now. And we are going to be requiring some sort of proof of residence. We're going to break out proof of identity versus proof of residence. And that proof of residence, we're grappling with whether it's going to be 90 days to 120 days, certain documentation for confirming that residential address that is on your application. It needs to match.
Which will probably be something like a utility bill.
If it's not on your license or on your Wyoming identification. If your Wyoming identification matches with what you have on your registration form,
Then
you're good to go.
Okay.
And then you've cleared both boxes, identity and residency. But if you don't, then you go to the next box to clear residency separately from identity.
Got it.
And there are other documents that just clear identity. So things like birth certificate, there's about 15 to 20.
Right. Okay.
So
Representative Haroldson?
Mr. Chairman, just real quick, so we have a definition for resident, but not bona fide resident, is that correct? So if that's the case, where did we get bona fide resident in the drafting if we don't actually have a definition of it?
Secretary Gray?
Oh,
You know?
Mr. Chairman, I think beefing up bona fide resident is something we could do, but residence is already in there. It's challenging to get outside of intent. The better way to go, I think, is to just clear the durational aspect and in the future maybe align bona fide with residence or whatever. I mean, but really getting that durational aspect in there is the question, because you're really not going to be able to, for the purposes of an attestation, get outside of intent. And then we've got the documents required for the registration rules to prove identity and registration.
Any follow-up?
Mr. Chairman, I do want to, I think I was pretty clear, but I just want to be a little clearer on this question of the Voting Rights Act. I do not think we need to be explicit as to this situation. I believe federal statute is already clear that if you do not meet the durational aspect that would be in state law if this passes, that you would be able to vote in your state that you resided in before, either by mail or in person. And if we explicitly add that, then we get into the issue, we get into a host of other issues if they're eligible in Wyoming. So I think they've made it very clear. It's in the statute itself, and then in that concurrence that they're eligible in their previous state. And it becomes a huge administrative burden on our election administration officials, largely our county clerks, if we don't allow the current federal statute to stand, that they're allowed to vote in the state in which they've resided before. Thank you.
All right. Thank you, Mr. Secretary. County clerks. Do you have anything to offer? Change your mind? Ah,
Mr. Chairman, my name is Malcolm Urban with the County Clerks Association. We really have nothing to offer on this. We've said everything previously, and Representative Newsom was asking some questions that we had had previously, and I think we were provided our answer here today. So, Mr. Chairman, we are here simply as a resource. If you have any questions for us, we're here to answer them.
questions for the County Clerks Association? Representative Ottman.
Thank you, Mr. Chairman. Earlier I asked about adding county to that. Do you see that as a plus or a problem, or it doesn't really matter? Thank you.
Clerk Irvin.
Mr. Chairman, I've got to be careful when answering questions like that because we don't want to be perceived as advocating for or against any sort of policy. The way we approach it is always from an administrative lens. And so the question of a 30-day residency requirement for the county in which you reside might be a problem in terms of an administrative capacity. The way it's written now, it aligns with what we're used to when verifying resident status or your voter registration qualification. And so the way it's written now would be more in line with what we're used to. So, Mr. Chairman, I know that doesn't answer Representative Ottman's question, but that's what I have to offer, unfortunately.
Does that satisfy? No answer is still an answer. All right. All right, thank you, Clerk Irvin. Public testimony. Welcome, Ms. Russell.
Kathy Russell, Executive Director for the Wyoming Republican Party. Thank you, Mr. Chairman. I'm going to just give some brief comments that have come out of discussions about this issue within the state party in central committee meetings and conventions and so on. And the primary concern, in fact, we just did a poll of we sent out about 7,000, I'm sorry, it was a little over 5,000 letters requesting people to mark in order of importance the priorities that they have that are important to them. And election integrity and voter ID is primary among them. I think what's driving that is a couple of things. Number one, if you own property here and you have skin in the game, you want to protect your right to influence policy. The next thing is the one man, one vote concept, making sure that you don't have people crossing lines to vote. And we do know we have a lot of snowbirds, that's been alluded to. And Representative Yen did bring up an interesting question about how do you determine residency. And my understanding is that if this were to go to, and I'm not a lawyer, I haven't read these records, but my understanding is, where are you more than 6 months out of the year? Where do you rest your head? Where do your kids go to school? What do you declare as your primary residence when you are when you're filing your IRS taxes? So those are some of the issues that could be used to determine a bona fide residency. One of the things that is becoming very apparent to a lot of people, if we have a lot of people moving in and out of the state all the time, the tiny home movement, the traveling medical staff, they can be here for 6 weeks. That's well above the 30-day residency. We have at this point no way to cross-reference with other states to determine whether or not they are indeed a resident here and not registered in another state. We have no way to find that out. We simply have to refer right now or rely on the attestation. If somebody's determined to vote in more than one place, and there are examples of it that have been revealed and have gone to court cases, that is not unusual. And so I think the issue that was brought up about defining bona fide is critical. I wonder if it's a historical artifact. I do think it was used in prior legislation, and I do wonder if bona fide did have a meaning at one time that perhaps could be dug out again. I don't know that for sure. Proof of residency. That's there also is little effort that can go because of time constraints and people constraints to verify proof of residency. I am aware of county clerks who will at least go to the extent to check the assessor's office records to see if somebody has a property that they have purchased at a particular residence. That's rare. I do know in other counties they can't even do that. As a county chairman, I had someone who was voted in as a precinct person and listed a warehouse as a residence. And when I went back and asked, how was this verified? They said, we don't have time to do that. And so that issue is out there. When you register a student for school, you have to show that you live within the district by either producing a lease, a utility bill, or some other thing that shows that you've had other people verifying that you are occupying that building. So there are methods to verify residency, but it's going to take an effort. And I don't know, I think the voter registration and providing that proof upon registration is perhaps one of the ways to do that. Again, I want to just reiterate that this is an issue that is very important to the people of the state because we have seen a big influx of people in the state. And we do have policies that are near and dear to our people's hearts. And they want to make sure that their voices are heard. Thank you, Mr. Chairman.
Representative Yin?
Thank you, Mr. Chairman. Ms. Russell, I know you were saying that right now we don't have a way to check if someone's registered in another state. I know that many states right now do share residency data across state lines to other states. Is that something that you would advocate for us to use to fight voter fraud, to make sure that we know who is considered a resident in another state?
Absolutely. And this has been brought
Ms.
up.
Russell,
I'm sorry.
through the chair.
Mr. Chairman, Representative Yen, that is something that has been brought up. So yes.
Thank you. Other questions for Ms. Russell? You got off easy. You got off easy. One question.
I'm sorry.
It's a joke.
I couldn't hear you. I'm
Oh.
sorry.
You got off easy.
Oh, yeah. Thank you.
Gail Simmons, Civics 307. I'm a resident of Sheridan County. I have a couple things. There's a presentation that is coming out, but I first want to talk about the bona fide. And what is interesting about this is when you go into 223102, it under parent A, parent 3, it says he is a bona fide resident of Wyoming as determined in accordance with WS 221102A XXX. You go to that one and it's repealed. So regardless of anything else, if having a definition, in fact, I would state that the statutes, Mr. Chairman, should either define bona fide itself or remove the word bona fide. So, back to the conversation, I believe, Chairman, that Senator Case brought up about the need for people to be able to go into the statutes and see in plain language what is and is not their rights and their requirements around voting. So I would urge either remove bona fide or redefine bona fide. So I have a concern about a definition of bona fide that rests solely on duration. Again, I think that was brought up in some other conversations just now about where it is that you reside. I know that there was a question, Mr. Chair, from Representative Ottman around county. And while the Clerks Association stated that that would be problematic around administration, the truth is that if you move from one county to the next, in that election, you're still entitled, regardless of what county, as a resident of Wyoming, whether you call it bona fide or not, to vote for statewide electeds. So if there was something put in around county, you'd now have to split the ballots so that you could distinguish those that have been in the county for whatever that as yet undefined definition of bona fide is from the remainder. So I think that the county is beyond problematic. The other question had to do with being a registered elector voter in another state. So for the 17 years that I was in the Navy and the 20 years that I worked for GE, I never established residency in any other state. And that was at the recommendation made to my mother from the then Secretary of State, that as long as you don't establish somewhere else, you remain a resident in Wyoming. So in the 49 years, I've not missed an election. It's always been in Wyoming. It's always been the place to which I was going to return as defined by residents. On the snowbirds, in almost all cases, those snowbirds that otherwise live in another state make sure that they meet that other state's requirement about their residency, particularly those that are other, the 45, I think, that have state income tax, where in order to avoid their state income tax, they're required to be in Wyoming for 6 months plus 1 day. If they register to vote in that other state and vote, they have just established that they're a resident for the purposes of that state income tax. So I don't think that this is a particular problem that we need to be concerned with, simply because it becomes self-limiting in terms of more than one vote. So again, especially when it comes to elections, policy needs to be in statute. I do not think it is appropriate for policy to be set in rules or directives in the executive or of the state or in the county clerks. They need to simply, outside of administration, the policy needs to be clearly stated in Title 22. So that's on the language of it. I'm going to switch over, unless there's some questions there, I'm going to switch over and go more quickly on this, on the data that I pulled. Okay, so Mr. Chairman.
Yes, I think you're good to go.
Okay, on page 2, what I did was, I think that you're all aware that I pulled Secretary of State data, 2 kinds. One, the registration data, as well as the voter history file, and I have that going back, the registration to 2014. And so what I did for 2022, beginning with the problem with not being able to get voter ID, is I pulled separately and I've identified all 305,335 unique voter IDs that were registered at any time between 1 January 2022 and 12/31/2022. So that's all that were registered. Some voted, some didn't. I'll get back into that. Some registered were registered on 1/1/2022, some were not. Of that, only 8%, or 24,651, of that 305,000 were not registered as of the 1st of January. So in other words, those are the ones that we're looking at when we're concerned about duration. So I split that off so that you could see kind of how they voted. So for example, of the 300,000, you can see that 65% between the yellow and the green voted in the general, and 60% voted in the primary. That's for all of them. And then 27%, and this is kind of problematic for me, but a different conversation, 27% who were registered and didn't vote at all. So then I took, on the upper right, you can see that of those 24,000+, we actually have the voted in the general 77%. So of those who registered in the year, they were the one, they had even a greater likelihood of voting in both. So when a concern is that people fly in, vote, and then fly out, unless they're doing that twice in 1 year, that's not logical. And then 65% voted in the primary. And again, only 22% voted just in the primary, which I think we all know is 100% of the county positions were determined in the primary. 67% of the legislative position were determined in the primaries. So that is it's all over, but the shouting on most at the end of the primary. So if you go to the next page, I wanted to take a look at this timing. So all primary voting, and this goes back to all of those that voted in the primary, basically the 65%, 40,000 plus 157,000. What you see is I went back to look at what was their registration date. So I could determine, was it within 30 days or outside of 30 days? And you can see that 50% of all primary voting was in fact within 30 days. That is, that there was a registration date on there and I could determine that. Now, does that mean they're a resident or not? Doesn't matter. That's when they registered. The bona fide, as I said, isn't defined. 20% were in advance. And then there was 30%, and I'm going to come back to this again, 30% where there was no registration date in the WildReg system. And I think there's a problem there that I would ask the Secretary of State's office to look into, because we shouldn't have required fields that blank out. Now, of the ones that were registered previously, that means that they either had been registered and they let it lapse, or they were registered coming into the year. You can see the split. And then on the new registration, you can see new registrants overwhelmingly are registering well before the 30 days. And these are the new registrants, the ones that had never had a voter ID previously. And that's for the primary, the one that causes the most concern, particularly for the majority major party. Problematically, you can see in the lower right, of those that voted in 2022 that were inactive in 2023, and I use that if they were inactive in August of 2023, all but 4 of them, there's no registration date. So there's some kind of glitch in the system that I think needs to be fixed. I can determine that they were registered before because they couldn't have had a voter ID in a prior year if they hadn't been registered. And then you go to the general voting, and again, we actually see a flip here where we see the new registrations are within the 30 days, and registered previously was no. So it's kind of a switch over from primary to general, and I think that that's probably in keeping with kind of the realities of what these elections mean. And again, you can see very few of those who voted in the general are now no longer active, which makes sense given the way in which we conduct our cleansing, if you will, of the data. So if it's only those who didn't vote in the general that go out and get asked if you don't want to be. So it's the primary only that's the ones most likely to be told that unless you tell us, we're going to inactivate. So those are very few numbers. Again, the point here is having data-based decision making. I think 30, a duration of 30 is fine, but I have a considerable issue with not having bona fide defined in statute, and for anything having to do with voting not be statutory, should not be rulemaking, should not be directives, absolutely needs to be in the statutes. And I stand for questions.
Committee, questions? Representative Ottman?
Thank you, Mr. Chairman. And just to go along with the bona fide, because I had a question with that as well. And then when you referenced the statute here in 22-3102 AIII, which you referenced, he is a bona fide resident of Wyoming as determined in accordance with WS 22102A XXX. And then when you go over there, and it says as per that in statute. And then when you come over here, it's a place of a person's actual habitation. Construction of the term residence is a place where a person has a current habitation into which whenever he is absent, he has the intention of returning. Employed in the service of the United States or the state, a student, no, I wanted to go up. Yes, kept at a hospital. But anyways, it does go down through and says exactly, it goes through there for quite a long time. And a person shall not lose his residence by leaving his home to go to another state, another district of the state, or another country for temporary purposes with the intent of returning if he is not registered in another state, district, or country. So it pretty well.
Mr. Chairman, Representative Ottman, on the bona fide, it actually references, so the residency, when it references residency, it does in fact reference what you had said. But when you take a look at the one where it references 22-102A3, that actually, when you look at it, it basically says 22-102 repealed in its entirety. Yeah, 22-2102. So 22-3102 references 22-102, and 22-102 is repealed. So again, we either need to, and I'm concerned about this, and you probably don't have time to clean it up now, but if this is going to be enacted, it needs to be enacted with a definition.
Mr. Plum, when I do just a quick search of bona fide resident, I see it populate a couple of times in Title I. For example, under the change of name statute, we use bona fide resident as well. Do you know, do we define, in those statutes, do we define bona fide resident? Or anywhere in the statutes? Do we have an actual definition that includes bona fide?
It's a great word, though.
Bona fide.
Mr. Chairman.
We
Yeah.
could just say, maybe we could just say real resident.
Yeah, Mr. Chairman, I haven't found like a true blue definition of bona fide in statute. I mean, residence is defined and, and those kind of things, but yeah, that's just a term that's, frequently used throughout statute that I don't think I've found a specific bona fide means this.
That's the same with my search. Okay.
Question.
Mr. Co-Chairman.
When Senator Boner married his wife, did she become bona fide?
Ooh. Ooh. Ooh.
No, it's not. It's terrible.
All right. Mr. Rubino, did you have something?
Mr. Chairman, if I could just provide a clarification since it's germane to the discussion.
Yeah.
So the question was whether 22-3-102 referenced a statute that was repealed, and it doesn't. 22-3-102 subsection A, Romanet 3 says he is a bona fide resident of Wyoming as determined in accordance with Wyoming statute 22-1-102 subsection A, Romanet 30. So it's not 22-2-102. And then 22-1-102 subsection A, Romanet 30, that goes to residents.
Mr. Chair,
Yes.
I stand corrected, and it's still not defined.
Yeah, I'm not struggling with that as much. I think resident, it seems like resident is defined, which we're citing to it. Bona fide appears to just be terminology that's being used in the statutes to supplant the word real is all it's doing. I mean, we're saying that you're a real resident. I don't know that if we've defined resident, I don't know that we have to define bona fide in order to have a clear statute. Am I missing, or what am I missing?
Mr. Chair, I think when I'm reading something and I'm new and I see bona fide resident, I'm like, okay, I consider myself a resident. How is that different from bona fide? So my point is that if we're not going to define bona fide, remove bona fide and just make it resident, because we have residency clearly defined.
Okay. Secretary Gray.
I mean, I think, Mr. Chairman, in terms of statutory construction, I mean, I think the word bona fide has a clear meaning, which is, like you said, genuine or real. And I suppose you could put that in there, but you don't, in the statute all over the place, we don't define terms that have a clear meaning. And the point there is, it is a protection against someone here who's here 30 seconds. You know, there could be an argument made that's not a bona fide residence, and that's why you put that in front of there. Is it a super strong protection, as strong as a durational residency requirement or the registration requirements in statute? I don't think it's as strong as those, but removing bona fide weakens the statute considerably. I suppose you could put bona fide means genuine or real in the definitions, but I don't think it's needed because the definition's clear. It's just a substitute for real, like you said.
So, Mr. Chair,
Yes.
I think the distinction here is my concern is about the validity of the voter, not the protection, the protection of the individual's voter rights, rather than the protection of our system. So it needs to cover both. And I rest.
Okay, thank you. Rest away. Other public testimony. Anyone else testifying on this bill? If so, you can just move up and fill up the chairs now. And then we'll go, we'll jump to online next.
Thank you, committee. Good morning. My name is Marguerite Herman. I'm testifying here as a member of the
Is that
legal.
microphone on?
It's green. Is that?
Oh, yeah,
correct?
maybe just lean into it a little more. I can hardly hear you.
Thank you, Mr. Chairman. Here for the League of Women Voters. And just to make it clear that the League has always been in full support of the most rigorous requirements for registration to vote. We do have some issues with restrictions that are qualifications that are being put on actual exercise of the franchise, and believe that any qualifications, limitations put on that need to be completely justified, I guess is the word, that this is absolutely necessary, not a good idea, something other states do would make us more comfortable, but absolutely necessary to ensure the security and validity of an election. And I would argue that this bill has not reached that level of justification. We've talked about the problems with use of the term bona fide, real, as opposed to what? Unreal. I mean, people do live with relatives. They don't have a utility bill. They are real voters but I guess bona fide residents, again, as opposed to what? I just don't know. And residency can be determined by the clerks as a point in time. Today, when I'm registering, I live in this location. But at the polls to determine if they are still there for 30 days. I mean, I guess the other part beside the bona fide, and I won't beat that horse, is the practicality of administration, because as we all know, election season is very difficult for our county clerks. They do a great job, but before we give them something else to do, records to check, verify, that we really make sure that it's absolutely necessary once again. And I don't think I fully appreciate all the checking that will have to be done when a person comes to the polls. You registered at this address, are you still at this address? And adding county to it, I'm afraid would just add another layer of, a phrase they use in the labor committee is, the juice isn't worth the squeeze. And so I won't use it here. I don't know if it applies, but I'll just say the effort does not actually improve the process. I don't think moving from one county to another should affect someone's ability to vote in a particular election. Again, let me see. So the practicality of it, determining what a residence, how to determine that before an election, how to determine on election day or at the polls for early voting. How long have you been at that residence for 30 days? I mean, I just see this as not producing enough value to make it. I don't think those boxes have been checked yet with this particular bill. So for that, I would have to say that I don't, and then on the bottom line, does the current system, I mean, I guess people, there are holes in it. People say there are holes. I haven't seen the holes. I haven't seen data on the holes, but assuming that there are holes, I think that the current system has to, I think you do have to sort of demonstrate that the current system is flawed, and to what extent practicality before you would, again, impose qualifications and limitations on someone's exercise of franchise. Absolutely, registration should be as strict as possible and purged and all those other things, but I think the bar has not been met in this bill. Thank you.
Questions? Ms. Herman, in Ms. Simon's presentation, one of the bullet points here says that all but 4 registrations were within 30 days, were prior registered voters. So it seems like the number of voters that fall with outside of the 30 days was pretty minimal. So ultimately, what's the risk if the overwhelming majority of them were already registered voters?
Well, Mr. Chairman, I would respond that what's the benefit of imposing this duty or this qualification if in fact there is not a problem?
Okay, that's fair. All right, thank you, Ms. Herman. Online testimony. Do we have anyone online who wants to testify? Do we have anyone online?
Yes.
Oh, if you're online and you wish to testify, go ahead and raise your hand. Or your virtual hand. We'll finish out in the room here and then is anyone else in the room testifying? Because I already asked that question and the intent was to get everyone lined up. You're it. All right.
You have a green light, ma'am?
Does not, now it does.
There you go.
Thank you. Patricia June at Campbell County. And sorry, I wasn't intending to speak, but
That's all right.
one of the questions that keeps being brought up that was addressed or talked about in Douglas that left me very perplexed. And that is, if we have not had a problem with it, then why are we addressing it? And I don't understand why you would not want to be proactive rather than reactive. That's essentially what I have to say.
Any questions, committee? All right, thank you for your test. Oh,
Mr. Chairman, I'm sorry.
Mr. Co-Chairman.
Ma'am, I think that's a really good question, and I kind of throw it back to you in the opposite, though. If someone is entitled to vote and they're discouraged because we make it difficult, is that a harm as well? So it kind of cuts both ways. What do you think?
Mr. Chairman.
Yes.
Senator Case, I can see your point to a point. What I really see is if we have one fraudulent vote, you can't remove that vote. And we need to do all we can to make sure that our elections have integrity.
Mr. Co-Chairman.
Let's turn that around again, ma'am, and just see if we have 10 people that are discouraged from election but are entitled to vote. They're discouraged because our law is not clear or they're prevented. And this is kind of a quagmire when you look at the sticky wickets from other states and where are you going to vote for your president? And now we've got counties rolled in there. Where are you going to vote for your statewides? And so if people are discouraged from vote, say one person is fraud and 10 are discouraged, I would argue that discouraging is a pretty bad thing too. And I'd like to get your reaction to that. So if 10 people are prevented from voting, who should have voted because we're not clear or they can't prove it up, is that as big a problem with our election system as a one fraud that you mentioned? I think it might be a bigger problem, but that's my thinking. I'd like to know what you think.
Please.
Mr. Chair, Senator Case, putting me on the spot to respond to that. I really do believe that our elections, our codes, our statutes need to be very clear and they need to be spelled out.
Mhm.
If that discourages someone, then that must mean that they don't meet those qualifications.
Wow. We can have more discussion. Thank you, ma'am.
Thank you.
Okay, thank you. Now in our online world, how many do we have? Just one, okay. Welcome.
Yeah, thank you, Mr. Chairman, and thank you for allowing this remote public comment. It allows me to work during the day and not travel there. And I'm up in Sundance, Wyoming, where we're getting our first snow of the year. So I appreciate not having to drive in it. I wanted to reference real fast that data. I didn't see the data that was shared by Ms. Simmons, but I heard her testimony about it. And I'll note that the data points in there actually support the crossover voting bill that passed previously when she noted that 50% of folks registered 30 days prior to the primary, which kind of goes to the whole point of that. So I think that data should be carried over into that discussion. But in regard to this bill, I'm in complete agreement with taking up a durational residency requirement.
Sir,
In regard to the,
Sir, did you introduce yourself?
yes, I did. My name is Mark Kepp, and I'm a resident of Sundance, Wyoming, and Crook County.
Okay, thank you.
If I didn't, I apologize. So there you go. Yeah, my name is Mark Kepp. Again, I'm in complete agreement with the durational residency requirement. In regard to changes, I actually have, for the conversation about bona fide, I actually have a very unique perspective on this. For 12 years, my family and I were nomadic travelers. We lived in an RV full-time and had no residence. And I actually had to go through the process of becoming a resident of Wyoming, primarily for healthcare reasons, not for voting requirements. And I can tell you that it was very difficult to establish residency. And I actually had to go through a number of steps to do it. Again, I wasn't looking to cheat the system to vote or anything. I was just trying to establish residency in regard to healthcare reasons. So the bona fide definition, that's actually a common English definition. There's a definition of it. So I think it's good use of that term. And I can tell you that this topic of defining residency and so forth, it is very challenging with the way people live nowadays. And there's so many variabilities in how folks travel, how folks work, and all that type of stuff. And South Dakota actually just went through this debate last year in their legislature because that state is more forgiving on residencies and voting requirements. And a large number of full-time RVers, which is what we were, are residents of South Dakota because of their tax laws, vehicle registrations, and voting requirements. And it created quite a firestorm for them. So I can say that from that perspective, Wyoming is already pretty challenging if you're trying to follow the rule of the law in regard to residency. But I do agree with this durational residency requirement as you have it written now. With that, I thank you, and I'll take any questions.
Committee, any questions? No questions about the life of an RV traveler for over a decade, and sounds like a fascinating lifestyle. All right. I tried. Thank you. Anyone else online? Anyone else in the room? Okay, we will close public comment. Committee, what is your pleasure? And moved by Representative Haroldson and seconded by Representative Ottman. Let's take a look here. Any amendments to page 1 of this bill?
Mr. Chairman, was there a suggestion, I think Luke did, for instead of an effective date, put immediate?
Okay, you want to jump to I was going to go page by page.
Oh, that's on the front page, I thought.
Is it? Oh, short title.
Oh, sorry.
You're looking at the short title.
Okay, well, we can go later.
What was the suggestion you wanted to make?
What would it be? As soon as it becomes law?
That's what
Pardon me?
I think that's what it does.
Oh, does it?
Section 2,
Already
page
does it?
5, bottom of the
Oh, okay.
page. This act is effective immediately upon completion of all acts necessary for a bill to become law.
Okay, then, Mr. Chairman, what I'd like to do is take back the last minute and a half.
Okay.
Okay.
Oh, Senator Scott.
Mr. Chairman, when you get to page 3, I'll have an amendment for page 3 and page 4.
Okay, any amendments on page 2? All right, page 3. Senator Scott.
Mr. Chairman, page 3, line 19, after the word "been," add the words "or will be at the time of the election." On page 4, similar amendment. Page 4, line 9, after resided, or will add the words "or will have resided." Mr. Chairman, this is to deal with the confusion with the way it's worded right now. You're asked to swear that you have been a resident for so many days when you haven't yet achieved that number of days, but you're going to, and the circumstance where you are voting early absentee. So, Mr. Chairman, it's just clarifying language, and that's my motion, is to add those words in those places.
Yeah, draft 5. And this goes to Senator Boner's original intent, I think, or maybe not. Okay. Is there a second? Seconded by Representative Wiley. Senator Boner.
Yeah, appreciate the clarification. I have a question for Senator Scott, though. He made 2 specific references to making that adjustment, but that is language throughout the bill. I'd just like an explanation as to why we only did it in those 2 instances of that language and not in similar areas of the legislation.
Senator Scott, assuming you want that to conform throughout the bill.
Mr. Chairman, I don't think that it was necessary in some of the other places. These are the 2 places where I can see that somebody is swearing to something.
I'm confused by that. Like on page 5, G, why would we not want the same language there? Senator Scott, who's gone?
Mr. Chairman, on page 5, qualified elector means a natural person who has been a bona fide resident of Wyoming for not less than 30 days before the date of the election at which he offers to vote. That's the general principle. What we're doing is people are swearing to that, but if they vote absentee, they can be swearing that they have done something when they haven't yet done it, but they will comply. Essentially, they're saying they will comply. So I don't think it's necessary in the other places. I think it's just necessary in those 2 places.
Yep, so our committee's clear. Can staff, I don't know who's got it, Mr. Plum, if you have it, can you restate the amendment for us? It's a little tricky over the Zoom world to get that.
Yes, Mr. Chairman, thank you. On page 3, line 19, it would state, he has been, and then it would insert, or will be at the time of the election, a bona fide resident of Wyoming.
And
And then on
And on page 4, yep, sorry.
Page 4?
Page 4, line 9, I have resided or will have resided in the state for not less than 30 days.
Okay.
and Mr. Chairman,
Senator Scott, yes.
Mr. Chairman, it may be that you really don't need the one on line 3. It may be the only place you really need it is in the oath.
But Senator Scott, can you repeat the last statement you just made?
Um,
I'm having a hard time hearing you.
Okay, sorry about that, Mr. Chairman. On the page 3, line 19, I'd really ask the LSO, do we really need the new language there, or do we just need it in the oath?
We have a housekeeping amendment to, or housekeeping thing.
Okay. Mr. Plummer, Mr. Anderson, did you hear Senator Scott's statement?
Mr. Chairman, I believe what he was saying is that you may not need the amendment to page 3, line 19, and just in the oath on page
Right.
4.
And so my question is, do you have an opinion to offer us on that?
Mr. Chairman, no, I think you could, as was noted earlier, you could put it everywhere throughout the bill, or if Senator Scott was mostly concerned about the oath, so I think his amendment would appear to be just on page 4, which is strictly dealing with the oath.
Okay, gotcha.
Time out for.
Mr.
Hold on, Senator Scott, one sec.
Senator Scott, we got a little housekeeping thing. Senator Barlow, go ahead on your housekeeping.
Thank you, Mr. Chairman. So it's come to our attention that the version online, which is 0.5, is different than the version that was provided to the committee as far as line numbers. And that, so folks that are following remotely and have access to the internet version, the amendments that are being offered will not conform to what you are seeing online. So there's just a bit of a disconnect here about that. And maybe it's a technical thing or something, but we're both looking at version 5, and mine is very different than what the chairman is looking at. So just a note for the public out there that it's not tracking right. It's because it's not tracking right. Thank you, Mr. Chairman.
You're using the online version then, Senator Barlow? Is that?
Mr. Chairman, I'm using what the entire public has available to
Okay,
them,
gotcha.
which is different than what is provided to us. Thank you,
Okay.
Mr. Chairman.
Just to dig in, this is working draft 24 LSO 91 working draft 0.5. That's what. So that's the same as online.
But the numbering doesn't line up. Okay.
Do the line numbers, are they consistent by page or do they lap?
Page 3, you're on page 4.
Can I see? The line numbers are good.
So you pull up page 3. Pull
Yeah.
the bottom of page 3.
Hold on, Mr. Chairman, sorry. Yeah, he's definitely correct. So for example, the online version that the public's accessing, the bottom of page 3 is actually on their page 4.
I see it.
Yeah, so, yeah, apologize to everybody about this. We didn't know this. But I think we could work through it. We can go by it looks like for your folks online, you're gonna find the reference a little farther down. And then we're using a copy in our e-notebooks, and it's gonna be looks like there's a shift of about 3 or 4 lines, essentially, is what's happening. So we're very sorry about that, but hopefully we just have simple amendments and the public can help us along. Back to you, Mr. Chairman.
Yep, I would just say if you're if you're online or in the room and you are confused on this amendment or a future amendment, feel free to come up and, or catch our attention, and we'll try to make it clear what we're doing here and where we're doing it in the bill. Senator Scott, then, you've already made your amendment, but do you want it to only apply to the oath?
Yeah, Mr. Chairman, if it's all right with the second, I would say let's just do it with the oath on page 4. That's the place I think it's going to cause confusion with the public.
Representative Wiley, are you good with that? The second agrees. Everyone understand now we are only amending the oath. It's on my page 4. I'm not sure where it's at on the online version.
Mr. Chairman, page 4, line 14 for the online.
Okay, so we're looking at page 4, line 9 in your working draft, and page 4, line 14 in the online version. All right, any further discussion on this amendment? Seeing none, all those in favor signify by saying aye. Aye. Any opposed? That amendment has passed. Any additional amendments to page 4?
Page 5.
Or page 5?
Depending which version you have.
Page 5. Page 6 is just a staff comment. Page 7 is staff comment. So, Senator Barlow, you have something?
So, thank you, Mr. Chairman. So in response to the staff comment, I do think that we need to, I would like us to be explicit about the presidential and vice presidential issue. And while the good Secretary of State's office did outline that there still is an opportunity for that person that moved here that had not lived here 30 days, sometimes that may not be practical, move here for a job, et cetera, 5 days, et cetera. So I do think we ought to provide something. I have some language that I did work up, but based on where we are with maybe 2 different versions of this bill, I think I'm just going to bring that forth maybe in the session, should this bill pass out, and at least have that discussion in whichever body hopefully introduces this bill and works this bill. So I do think there's value, and I'll just read the language that I've worked with just a little bit. It's basically goes under the 103, verified, that's 10, well, depending on what version you're in, still in the same place in statute, but depending on the page, it would basically say, be a subsection B, would be any elector who meets all the requirements of subsection A, except has not resided in Wyoming for 30 days or more, shall be qualified to vote by provisional ballot for president or vice president only. So I think that speaks to the potential that someone would come in and say, I am qualified to vote for president or vice president, and this would lay out a process, a statutory process for that to occur. So I'm not going to offer that as an amendment unless there's a strong feeling to do it at this point, because of where we have 2 versions of the bill working that completely new language in. So thank you, Mr. Chairman, and concept. Thank you.
Co-Chairman Case.
Mr. Chairman, I would encourage Senator Barlow to offer the amendment, because that way the public will have a version before we get to the public will be better informed if we offer the amendment. They might not know, based on our confusion today, exactly which line that's going on, but I'm not persuaded by the argument from the Secretary of State's office that you can always go vote in the place where you came from. That seems extremely cumbersome to a voter. When we turn them away and say, you can vote for president where you came from. I'm not so sure that that's true, because we don't know what the law is where they came from. Yes, of course, federal law says they can vote in the presidential election, but what if they are exiting the previous state and their law says that if you leave to make your residence in another state, you lose residency here? We don't know that. So I would encourage you to offer it, even if it's somewhat conceptual based on our line number confusion today. I'm not persuaded that it's unnecessary.
Mr. Chairman, so I've emailed it to the committee. I'll give time for other people to ask questions and they can review the potential language. Thank you.
Representative Newsom.
Thank you, Mr. Chairman. I think going forward with Senator Case's argument is, what if they have not been registered in their prior state? What if this is their first registration to vote? And so I think you run that risk of saying you can't vote here because you have not met the residency requirement. They've not been registered in a prior state. And so now they're out of luck. So I think it's important that we have this amendment in the bill. Thank you.
Mr. Chairman.
Yes.
Excellent point. I mean, I can't see what we're not going to say, well, you can't vote here, but you go back and vote in your other state, and the other state says you don't live here anymore. You don't meet our residency requirements. Good point. Good point.
Kate, does someone want to offer the amendment then?
I'm trying to make
Officially?
Carlo offer it.
Thank you, Mr. Chairman. So if you look at your emails, you will see a email from me, and there's only one version, so hopefully it's accurate. And it would be to insert into, and I'll go to the page on my bill, or on the bill that I have. Or maybe I should go to the one that the committee's working off of.
Okay, thank you.
Ain't technology great, Mr. Chairman?
Yes, indeed.
Mr. Chairman, maybe I should give staff some latitude to where to place this, but it probably goes under the definitions and would be a sub-definition under there. We have to be careful we don't change the definition of qualified elector in this, because we're actually making an exception to a qualified elector by this type of language. So it's conceptual. We maybe give it to so the language before you, committee, would be any elector who meets all the requirements of the qualified elector, except has not lived in Wyoming for 30 days or more, shall be qualified to vote by provisional ballot for president and vice president only. Mr. Chairman, so there's a second, I guess.
Seconded by Representative Newsom. Go ahead, Senator Barlow.
Thank you, Mr. Chairman. So I guess the point of this is, I think, let's take any ambiguity out and do it within Wyoming statute. And I think I use the word provisional ballot intentionally because that's something that is actually set aside, and then, in my understanding, and then the clerks go through those in a different sense. So maybe I'm wrong, maybe provisional ballot is not the right word there, but I think that at least takes it out of the automatic system, and maybe there's a way we can come up with, through the clerks and through the Secretary of State's office, how that would be handled. But I think the intent is clear that the problem is are we going to have a separate ballot? Practically, are we going to have a separate ballot that only has president and vice president? Or are we going to have some means of limiting someone to only those fields on an existing ballot? So that's a practical question that I don't have an answer to. So that's the amendment, and I'll be glad to stand for any questions. Thank you, Mr. Chairman.
Any further discussion on the amendment? I was going to ask if the clerks want to weigh in on that practically. What would this look like?
Here they come.
Welcome back, Clerk Irvin.
Thank you, Mr. Chairman. Malcolm Irvin, Platte County Clerk, and with the Clerks Association. With me is Julie Fries, the Fremont County Clerk and the brain of the organization. And Clerk Fries, really, and I'm going to turn it over to her, had a good question about the provisional aspect, and we understand the intent of Senator Barlow, certainly. There are some things we would need to work out, and
we're not looking for questions, we're looking for answers.
And mull over and discuss. Well, Mr. Chairman, we might have to look elsewhere. If we have a little bit of time just to mull on it, I think just a couple of our questions, if we could get them answered, and then it would provide us some direction.
Mr. Chairman, Julie Fries, Fremont County Clerk. Thank you for allowing us to come up after you're discussing this. I already fired you guys off an email on this. So when you do a provisional ballot, then the voter has an opportunity by 5 o'clock the next day to bring whatever is deficient to the county clerk, and we bring it to the canvas board. So my question on this is, what are they going to bring to us? We don't have a way to check with other states to make sure that they didn't vote somewhere else. So that's my concern. I mean, I hear nationwide that the presidential race is the one that everybody's concerned about. And yet we're trying to find, and I understand though, I understand the whole process and what you're trying to do. I'm just saying that that seems to be a big area to be very careful with. So I do know somebody talked about that there are other states that do have that connection. I am going to try to reach out to those. I did see that on a roundtable discussion thing that I have. I was going to reach out to them and see what kind of connections they have, because that is the end all, I hope, for America, is that we all are connected someday so that we can have the ability to make sure you're not voting in more than one place.
Well, whether we offer this amendment or not, though, the federal law still applies, and there still could be someone requesting that provisional or unique ballot. So how you need more time to think about what that looks like, or what? How does that? I mean, you have a separate ballot, is what you have to have, right?
And Mr. Chairman, I guess our question is, what are they proving to us so that we can count it?
Mr. Chairman,
Mr. Co-Chairman.
in Wyoming, the word provisional is a certain procedure. That there's not all the complete documentation, so you have till 5 o'clock the next day.
Correct.
To correct the missing information. So that's what it means, very specific. And that's not fixed by the federal law or not. In a very practical way, the president and the vice president are not elected by popular vote. They're elected in the Electoral College. It is inconceivable to me that there'd be enough fraud in Wyoming to throw the nomination from one party to another on the presidential ticket. I mean, that is a pretty big fraud. And it would take hundreds of thousands of votes fraud to change that election. So in a way, what's the harm if we grant latitude with respect to this? So I would suggest we take out the word provisional. And I do like Senator Barlow's amendment, but just take out the word provisional. And really, there's no harm done by this. None whatsoever.
And Mr. Chairman, I'm sorry, Mr. Chairman, just to clarify, what we're seeking is if it remains a provisional ballot, are we seeking to prove that they were qualified because they had not voted elsewhere, or they're qualified because they had not reached that durational requirement? And so really, our intent is to seek that clarification of Senator Barlow's proposed amendment. Are we seeking that they had not qualified because they voted elsewhere, or because they had not met that durational requirement?
Senator Boner.
So it's my understanding the intent of this amendment is simply to put statute, what's already required by federal law, for sake of convenience for the public mostly. And so that's my understanding. To answer that question, I guess I have a question of my own, is, this is currently a federal requirement. What's your current procedure to deal with this situation? Do you even have one? And if so, what would happen? Somebody moved here, 15 days ago. They can vote for president and vice president. What does the county clerk do?
Mr. Chairman,
Ms. Freese.
Senator Boner. So currently, if you come in, like was just mentioned earlier from the Secretary of State's office, so if you come in to register to vote and you have an address and this is where you say you're going to vote, you're put into a precinct and that's the ballot you get. The only ballot like that one is called the federal write-in ballot. So you're overseas or military and you have applied for a ballot, but it did not get there in time, or it's not going to get back in time, or you didn't receive it, I guess it is. And so there's a federal write-in ballot you can put in. I believe it's the president, vice president, senator, and US representatives. I think that's limited to that. That's the only ones we have ever received. The thing about that is they're already registered to vote, that whole thing. So they meet all that criteria. So another question I have, if you wanted to do it this way, is then are they registering with us? Is there another card we would need to have? What does that tell us? And I realize a lot of fraud would have to happen in Wyoming, but I think you're all very well that county clerk's under a lot of scrutiny. And I, for one, don't want to be under scrutiny. I think we do a good job. And so I think it's important for us to look at the big picture and try to, if we're trying to do some kind of residency requirement, then I say we look at everything and just make sure that we're covered as best we can. Because a lot of people look at us and say it's us that's not following the laws. And I just want to be very careful on that. Thank you.
Senator Boner?
So I'll follow up based off that. So perhaps this amendment is more than just, communicating to the public, since we are creating a new requirement that you be in Wyoming for 30 days. In fact, the clerks do not have a procedure because it's right now you just register to vote, right? If you move to Wyoming a week before the election, you get the ballot, the same as any other Wyoming resident. We would be changing that. And as a result, we should give some consideration to what happens when that person comes in and they're qualified to vote for, 2 offices.
Right.
We should probably give some thought, and whether we get that done today, I don't know, but we can give it a shot. But certainly, I'm very confident that we can, working with the clerks and with the Secretary of State's office, we can figure this out before the
I would
session.
appreciate that. Thank you.
Mr. Chairman,
Co-Chairman Case?
but doesn't it also bring up the fundamental reason why we're doing this bill, or whether we should do this bill? Because if we didn't do this bill, we wouldn't have this problem.
Just
Senator Barlow?
Thank you, Mr. Chairman. So in light of the discussion, I think I am quite comfortable removing the word provisional from this, from the proposed language, if the second is so inclined.
I forgot who was the second? Sandy, or sorry, Representative Newsom. Okay. Secretary Gray?
Yeah, Mr. Chairman, with your indulgence, I'd like to make a couple comments on this.
Okay.
Well, thank you. And again, this has come up pretty quickly, so I'm still trying to process this, but I think it's, to administer this, I think you have either 2 choices. It's not administrable, or you've basically decimated the 30-day residency requirement. Because if you're without the word provisional, even with the word provisional, so if it's a provisional, are they going to be able to vote all the races? Are we going to have 2 versions of the provisional ballot, one with just the president's and vice president's races, and then for this situation, and then one with the entire ballot for real provisional situations? So that's the provisional situation, where you get to this situation where you have 2 ballots, and you have the same exact problem when you remove the word provisional. I mean, the problem with administering this is you really can't have it both ways. We comply with the federal statute because it's very clear with that 52 USC 10502E that they're able to vote in their previous state. And that's backed up by the concurrence from Justice Stewart in Oregon v. Mitchell. If you try to have it where they can vote in that situation, then you have to have 2 ballots, which makes it almost impossible to administer. I don't see how that's the choice. And I don't see how you don't have it the other way. I don't think there's a third box. You're either going to have 2 provisionals, 2 regular ballots if you remove the word provisional, or you adhere to this section of the statute, which allows them to vote in their previous state. I don't think there's a third box, with all due respect.
Mr. Secretary, can they vote in their previous state if they've lost residency in that state? Because they could, or yeah, that could be the case too, but you could become a Wyoming resident conceivably all in one day. I mean, you could do everything that it takes to meet the factorial test of residency in one day, but only be in Wyoming for a couple of days and not meet the 30-day requirement. And you have to have the right to vote in a presidential election, but you've already lost residency in the previous state, unless you're a resident of both states, if that's what you're suggesting.
Mr. Chairman, I'd have to look at that a little stronger, but I think if they have the intent to return, which is a question in someone's mind, they would certainly have not lost residency because they have that intent to return, and that's
But
a
I'm saying they
standard.
don't. I mean, let's assume that they don't. They've done it. They've moved into Wyoming. They have a lease or they've bought real estate. They went and got their driver's license. They registered to vote and they bought a fishing license. They did all that in one day, but they haven't been there for 30 days.
Well, the fishing license could get you in trouble, Mr. Chairman.
Okay, the fishing license, we've seen that problem before. So my point is though, they've gone through a litany of things, but they haven't met the 30 days. They have a right to vote in our presidential election.
And Mr. Chairman, can I touch on
Yes.
this just a little bit? There's the residency issue of the other state, but they may not be registered as a voter. So the Supreme Court ruling from Washington that says you can go vote in your other state, if you weren't registered as a voter in your other state, how the heck are you going to establish residency when you don't live there? That's the part I don't get.
Mr. Chairman, I mean, you're asking about other states' requirements, but I think Justice Stewart's concurrence contemplates that and has that caveat. And says Section 202 added by the Voting Rights Act amendments of 1970 is a comprehensive provision aimed at ensuring that a citizen will not be deprived of the opportunity to vote for the offices of president and vice president because of a change of residence. Those who take up a new residence more than 30 days before a presidential election are guaranteed the right to register and vote in the state to which they have moved, notwithstanding any durational residency requirement imposed by state law, provided, of course, that they are otherwise qualified to vote. Those who take up a new residence less than 30 days before a presidential election are guaranteed the right to vote either in person or by absentee ballot in the state from which they have moved, provided that they satisfied as of the date of their change of residence the requirements to vote in that state, unquote.
Vivian?
Mr. Chairman, so basically what you read said we still have to have this process regardless of whether we have the amendment or not.
I don't think that's...
Is that, I mean, did I mishear what you said? Could you repeat it just one more time to say that you have the right to vote in the state that you moved in?
Moved from.
And I think
Then I misheard you.
And I think no matter what we do here, Secretary Gray, I think we have to clarify it in statute because you're reading a court opinion. And if we want this to be clear and transparent for our citizens, I think we need it in statute. We need to have it, even though I know it still has the same force and effect of law in the opinion. I understand where you're coming from, but all the clerks would have to know about this opinion. They would have to know how to interpret it. Every citizen would have to know that they have the right to go back to the state that they were from to vote. So wouldn't you agree that we need to put this in statute in some way or another?
Mr. Chairman, I mean, it depends what's in statute. I mean, the current amendment on the table, I think either decimates the intent of the bill or you have two ballots, which is not able to be administrated. Now, if you were to put in statute that you're eligible to vote in your previous state of residence, that I think aligns, and I did read from the concurrence, but there's also 10502E, which I'm happy to read again, 52 USC 10502E, which says the same thing. If we're going to align with that, I know we have issues with citing federal statutes, but it also kind of, from an interstate perspective, deals with another state, which I think is an interesting provision, but certainly from a notice perspective, if you want to put that in there, but that's not the amendment on the table. This is a very different concept, which I think either decimates the intent of the bill or requires two different ballots. You cannot have both. And this is the tension that we brought out from the beginning on this. Now, again, over 25 states have these requirements, and it has withstood constitutional scrutiny. And it has been a 30-day requirement in concert with this federal law allowing individuals to vote in their previous state of residence.
Senator Barlow?
Thank you, Mr. Chairman. So I want to be clear about the amendment, which the Secretary has not seen maybe physically, but it only allows for president and vice president. So I don't know what kind of decimation is being spoken of, but the amendment was very explicit about what they would have the opportunity to vote for. Thank you, Mr. Chairman.
Mr. Chairman.
Secretary Gray.
Mr. Chairman, my question would be, how do you implement that without having two ballots? Because or instructing them verbally only to vote the first two races, I guess. Would someone confirm that? You have to have two different ballots if they're only able to vote president and vice president, or you have to have 2 pages. You have to separate out the pages. And that's my point. And then if it's a provisional, then they're able to, then if they are able to vote the whole ballot, then what's the point of the statute? They're voting all the races. So you can't, that's my point. I probably shouldn't use the word decimate. I apologize.
Well, Secretary Gray, you said 25 states?
Over 25.
Over 25 states, the federal law still applies to those states. So the right to vote in a presidential election in the state where you reside still applies in those states. So do you know what they do? Do any of those states have 2 ballots?
Why don't you take this?
Mr. Chairman?
Mr. Rubino.
Yeah, if I may. Exactly. So I think the fundamental question you're grappling with here is what state has the onus, right, of allowing someone to vote for president and vice president? What federal law requires, as fleshed out by the court cases, is that it's the state that you removed from previously, not the state that you moved to. And so that's what they're grappling with. In Wyoming, it's codified. That is codified in statute. So Wyoming statute 22-1-102 subsection A, Romanet 30, again, the definition of residence, subsection E states, if a person removes to another state with the intent of making it his residence, he loses his residence in Wyoming, except that in a general election year, if his registration is valid in Wyoming, when he leaves this state and he is unable to qualify under the laws of his new state of residence to vote at the primary or general election, he shall be deemed to have retained residence in Wyoming for purposes of voting by absentee ballot in the primary or general election. I believe that is, I cannot go back in time to the intent of the legislature, but I believe that is the codification that you're searching for, is who has the onus? Is it the state that you move to, or is it the state that you remove from?
Right, Mr. Rubino, but you still have, unless I'm confused, you still have 2 ballots. Because even if you have the right to vote in the state that you left, you only have the right to vote in the state that you left in presidential elections, not every other election in that state. So even if you went back to the state that you moved from, you would have to have a second ballot. You would be given a presidential ballot only. Or you're suggesting that you would have a normal ballot and you would vote in all elections in that state that you left.
Mr. Chairman, I can't speak for the other 49 states, but I can tell you in Wyoming, no, it's not limited to president and vice president. And that's a conversation for another day. However, the statute, the plain language of that statute is that if you remove from this state and you don't meet the residency qualifications in the other state, you can vote here, and you would not vote in a separate ballot.
Senator Case.
Mr. Chairman, I was looking at that same statute previously as well, and I suspect they had this discussion when they drafted that before. But as we try to think this through a little bit, the practical implications, I'm not sure this bill does anything. I'm telling you, I'm coming out against the bill. But if we have a situation where a Wyoming resident moves to another state and they don't live here anymore, they have no intention. And we have a catch-all statute that says, even though you don't live here, you don't have any intention of coming back, you still get a vote here for all things on the ballot, not just president, vice president. And so I'm trying to imagine how this all fits together. I think they thought about it before, and maybe this bill's just not necessary. It opens more cans of worms than it fixes.
Mr. Chairman, can I respond to that?
Yes.
Thank you.
Secretary Gray.
Thank you, Mr. Chairman. These are 2 different situations. Chairman Case is dealing with the situation with an individual that has removed themselves from Wyoming who may or may not have the intent to return. If they have the intent to return, then they are eligible to vote. And that's already in statute. Now, then you have this other question of whether they're able to access a ballot. But what we're trying to address here is an individual that has not established residence in Wyoming yet. So I always bring back to the busing situation. The way the statute reads currently, you could be here 15 seconds, in your mind have the opinion that you are a genuine resident of Wyoming, that you're searching for a job, say in the newspaper, and it would be next to impossible, I would say impossible to prosecute. And that's what this is addressing, is somebody trying to establish a nexus and establishing that durational aspect. Now, Senator Case's situation is someone that has already established their durational aspect, already established a registration, and then moved, which I agree is another weakness in the statute that maybe we need to look at. Now, I don't know how, in concert with federal law, you fix that without 2 ballots, but that is a different situation. We're trying to address in this statute someone that is trying to establish a nexus, which could currently be done in 10 to 15 seconds if someone claimed they, in their mind, they were a bona fide resident. It's 2 different situations. Thank you.
Senator Scott, and then I'll go to Representative Knapp and Newsom.
Mr. Chairman, this gives me a little different perspective on this whole thing, and I think we need to back up and look at what this bill is doing. The fundamental problem we have in our society is that people do move around, and we want to preserve their right to vote. And I think I see a consensus developing across the country. Somebody said there were over 25 states that have similar laws here, that you vote in your new state unless you've been there less than 30 days, and then you vote in your old state. And I would think that the provision we see in our Wyoming law that was cited is probably pretty common elsewhere because it's a sensible way to deal with the federal requirements. And what it says to me is that the proposed amendment is unnecessary, because the way we're going to deal with it is say that, okay, in that last 30 days, the way you comply with the federal laws, you go back and vote where you were already registered. Now, if you didn't register, that's your problem. You've denied yourself the right to vote. But I think the proper solution here is to go ahead and pass the bill without the proposed amendment, so that we don't get into impossible things about provisional ballots that are unique ballots that you can't implement and still preserve a person's secret vote. So if I think we've got the problem solved if we pass the bill as it stands now without this proposed amendment, and retain the provision we have, that if a Wyoming citizen leaves and is going to cease to become a resident, they can still, until they've had the time to qualify where they are going to, they can still vote here. That seems to me the sensible solution, and one I would urge us to adopt by passing the bill in its current form without the amendment.
Representative Knapp.
Mr. Chairman, thank you. So question for both the clerks and Secretary of State is, as I'm understanding this, speaking on this amendment and questioning this amendment, we're worried about clarifying federal law or clarifying for a voter the 52 USC 10502C. This goes beyond that and actually adds to what would be that law. It doesn't just clarify and define that law for people. It actually adds to it by saying, yes, you can vote here. And I think administratively, would that be impossible to administer? I like the word provisional, but again, the intent isn't there because it actually adds another factor to what we were trying to clarify in the first place.
Mr. Chairman and Representative Knapp, that understanding is absolutely correct. We would face a choice at that point where you'd either need to have a page just with the presidential or vice presidential and vice presidential ballot, whether it was a provisional or regular ballot, which then becomes very difficult, if not impossible, to administer. I don't think the clerks are for that at all. I'll let them definitely give that statement. Or you provide that ballot in its entirety to that individual, at which point, why do you have a 30-day residency requirement? Because they're voting the entire ballot. So, and again, yes, it is expanding upon, it's not restating the understanding of what the federal statute requires, which is the ability to vote in your state of origin. It is expanding on that and then allowing them to choose whether it's the state of origin or the new state.
Representative Newsom?
So I'm going to go back to the practical aspect of this. So I'm 17. I'm moving from Idaho to Wyoming. I turn 18 on November 1st. The election's November 7th. I can't vote in Idaho because I was not of age when I lived in Idaho. I cannot vote in Wyoming because I have not met that 30-day requirement. So what happens with that person? The other point I want to make is that I think the clerks will agree that they have multiple ballots for different districts, different this, different that. So the ballot that I vote is different than the ballot from somebody that votes in town. So what is the problem with creating a ballot in each of our counties that just has the presidential election on it? I don't see, because the clerks have many ballots, different depending on where you live. So I don't see that that is a horrible, horrible thing, that there would be a ballot that just had the presidential election on it for exactly these circumstances that we're talking about.
Well,
Secretary Gray.
Mr. Chairman, would certainly allow the clerks to answer the second question on whether they're okay with having a supplement. In terms of the first question, I think that person would have been eligible to vote in their state in Idaho, because most states, Wyoming has this, and again, I can't speak to the specific drafting of the Idaho attestation, but Wyoming has an attestation that you will be 18 at the time of the next election. So you would have been able to register in Idaho because you will be 18 at the time of the next election. So if assuming they are in alignment with the Wyoming attestation, an individual can register now if they're going to be 18 before the next general election. I was actually just talking to somebody about this. So they would have been able to register.
Representative Newsom?
I think that the word assume. So we're going to assume that every other state is the same as Wyoming, and I would venture to guess that they are not. I would venture to guess that every state has its own if they have a residence requirement, that it is not mirrored with this proposed Wyoming residence requirement.
Mr. Chairman, I just got whispered that it was federal law here from our council that it is at the time of the next registration. So they would have been able to register because they'd be 18 before the next general election. And, everything is advantages versus disadvantages. Right now, an individual could set up a scheme where they bus in 40, 50, 60 people. And if somebody who wanted to participate in that scheme questioned and said, is that legal? I'm afraid the answer, and I'm not proud saying that, would be that it would not be prosecutable because there's no durational aspect in Wyoming statute. And so that's the tension that over a majority of states have said that they're going to adopt that durational residency requirement to take away that opportunity, that potential for fraud.
Representative Newsom?
So let me be clear that I am not against durational residency. I'm just looking at it from the potential voter's point of view, is what does it look like when I walk into my clerk's office, having the scenario I just presented. I turned 18, I want to vote. I go to my clerk's office, I say I want to vote, and they say you're not eligible because you haven't lived here long enough. You need to go back to Idaho. How does that work for the voter to be able to vote in an election that they want to vote in, where they've not had the opportunity to vote before because either they weren't old enough or they decided not to register? So as we look at this at a practical matter, I'm not against durational residency, I am wanting to clarify how this works in all these scenarios so that we can amend this in such a way that makes it clear to the voter how that's going to work for them.
Mr. Chairman, federal law, again, would have allowed that individual to register because they would have been 18 at the time of the next election. So they would have been able to register in their state of origin. They would have been able to register in their state of origin because they would have been 18 at the next election.
Co-Chairman Case.
Thank you, Mr. Chairman. I'm not sure what Idaho's going to do or another state's going to do, but we have the experts of Wyoming in this, right here in this room. So let me ask them, the clerks, in administering elections, have you ever had someone that had moved away but was denied the ability to vote in an election in another state for president and vice president? Have you ever had them come back to you and say, in any county, anytime, look, I moved to Kentucky, but they're not going to let me vote in the presidential election, and I'm not registered in Wyoming, but I need to get registered to vote? Is that possible? Is there a way to do that? Where they say, I need to, even though I live in Kentucky now, I'm going to stay in Kentucky. I'm going to miss the presidential election unless you let me register back in Wyoming so that I can vote in Wyoming. And Wyoming law says I can vote for commissioner and everybody else too. Has that ever happened? Has it ever happened that anybody can point to?
Clerk Irvin.
Mr. Chairman, Co-Chairman Case, it has happened. It's rare, but it has happened. Under current Wyoming law, like Mr. Rubino said, we do allow that. We re-register them, allow them to vote absentee. And Mr. Chairman, if I could just respond to some of the questions and concerns. First, on administrability, having a different ballot style is not impossible to administer. We're used to having multiple different ballot styles, so adding a ballot style is nothing new to us. The 2022 general, little old Platte County had 12 different ballot styles. So election judges are having to ferret out which one goes to you, the voter. So this is nothing new, and we even contemplate and say that on page 12 of our memo that we sent to you on August 22nd. Mr. Chairman, the issue is that the person turning them away and telling them federal law allows you to vote in your previous state is not you or me. It's the election judge on election day. That's the person who's going to bear the brunt of that conversation. If that's law, that's what they'll tell them. That's what they'll instruct them to do. But if there's a ballot that, whether it's provisional or not, that just has president or vice president, that's not impossible for us to administer. Simply our purpose for coming up here originally was just to seek that clarification from Senator Barlow of, if it's a provisional, that's okay. We can administer that. We just want to make sure that by 5 o'clock the next day, they proved to us one of two things. And the clarification was it they had not voted elsewhere, or that they failed to meet the durational requirement under this law. That was the original intent of us coming up here. But Mr. Chairman, I know that's a long way to answer Senator Case's question, but the answer is yes, it happens. It is rare, but it does happen.
Co-Chairman Case.
Follow up. It happens, it's rare. So we're trying to write a law where residents of Wyoming will go somewhere else. And we're being assured by the Secretary of State's office that this judge's opinion guarantees they're going to be able to vote. So just kind of flip it around. Unless it would be easier for them to vote in that other state if they had an amendment just like proposed by Senator Barlow, and we had an amendment just like proposed by Senator Barlow, because you said it's rare. And I want Wyoming people, when they leave, to be able to vote in those other states, or at least vote for president, vice president. I don't want them to have to do the rare thing or go through hoops. I want them to be guaranteed the right to vote for president and vice president wherever they are. And this amendment makes it easier. Yes, there might be a different ballot style. But if we get rid of that and say there's no problem, they can vote in another state, we just admitted that there's a problem because there has to be people that found it, that came to Wyoming because it's rare, that they didn't vote for president and vice president when they, in that election. The very fact that you say it's rare proves that out.
Representative Knapp.
So, Mr. Chairman, thank you. Secretary of State Gray, the concern I think that's been voiced several times is, do people have a guaranteed right to vote no matter where they're at, where they came from, whether they're here or voting in another state? Are they guaranteed the right to vote for president and vice president? I think that answer is yes, but I want to hear it from you. There's a difference between preventing voting and educating, even though it may require a second step or what is granted by law federally. It may require that. It depends on if we want to educate somebody with this bill as well, which I don't mind. But it's another thing to come up with extreme circumstances to say that somebody is not guaranteed the right to vote, which I have not heard any answer from you today that says that. Is that correct?
Secretary Gray?
Federal law is very clear that individuals have, that right for presidency and vice presidency transcends that durational aspect. But that it's allowed for them to vote in their original state, and that satisfies the requirements of federal law, and you would be able to have a 30-day residency requirement. So I think we're fine with the constitutional aspect to have a 30-day residency requirement for the entire thing. I think the clerks are saying they're able to do both ballot styles. That's now a choice. My preference from a policy perspective would be, I think that we allow it to be the state of origin for the presidential and vice presidential, but I do think the clerks now have said that they can administer another ballot style. In my view, though, I think from a policy perspective, it makes sense to have the 30-day residency aspect apply to everything, and then those individuals will vote in their state of origin for presidency and vice presidency, and potentially the entire ballot, depending on how the state of origin has their statute worded. In Wyoming's case, it is the entire ballot. And I would think, because of concern about ballot styles, most states probably are in alignment with that, although I'm not saying I'm positive on that. So.
All right. I feel like that's how you beat a dead horse. And we are definitely ready to vote on this amendment. All right. Any other discussion on this amendment? All those in favor signify by saying aye.
Aye.
All those opposed?
No.
That amendment has been adopted. There's a division. All those in favor of the amendment signify by raising your hand. 1, 2, 3, 4, 5, 6. Okay, put your hands down. All those opposed to the amendment signify by raising your hand. 1, 2, 3, 4, 5. What's that, Pepper? Yeah, I got it. Yep. So with 6 votes, that amendment does pass. We are back on the bill. Any other amendments to this bill? No, we got that. It was already in the bill. All right. Knowing that we've discussed this bill pretty thoroughly, we'll go ahead and do a roll call vote on 24 LSO 0091.
Mr. Chairman, roll call for 24 LSO 0091, voter qualifications, durational residency requirement as amended. Senator Barlow? Aye. Senator Boner? Aye. Senator Landon?
Excused.
Senator Scott?
Aye.
Representative Chadwick?
Aye.
Representative Harrelson?
Aye.
Representative Harshman?
Aye.
Representative Knapp?
Aye.
Representative Newsom? Aye. Representative Ottman?
Aye.
Representative Wiley?
Aye.
Representative Yin?
No.
Co-Chairman Case,
No.
Co-Chairman Olson.
Aye.
Eleven aye, 2 no, 1 excused.
Mr. Chairman, housekeeping?
Okay.
Could we just consider Senator Landon being excused on every vote? I'm so angry at him for leaving us and going to Ireland and dancing with leprechauns and stuff. I don't want to have to even hear his name.
Right.
I hope you're listening, Bill, and enjoying yourself.
Maybe he'll go back and at least review the tape. All right, folks, I think we should go ahead and take a 15-minute break. We'll be back 15 minutes from now. All right, we are back and we are live. And we are jumping right into the next election bill. We've got a series of election bills here. The next one is 24 LSO 0098, political party affiliation, declaration and changes. LSO is going to walk us through the bill.
Good morning, Mr. Chairman. Josh Anderson, LSO. So this bill was requested back at the May meeting, and then we discussed it previously at the August meeting up in Douglas. This version implemented an amendment that was brought at that meeting by the Secretary of State's office and related to clarifying when a person can declare or change their party affiliation. So you'll see bottom of page 1, we add the word of for a primary election, a qualified elector may declare or change party affiliation on an existing voter registration by completing an application. And then on page 2, starting on line 5, adds a new sentence specifying that nothing in the subsection shall prohibit an elector who is not registered to vote in Wyoming after the first day on which an application for nomination may be filed under 22-590-209 from registering and declaring a party affiliation before or at the next primary election. And then at the amendment of the last meeting, we also made this effective immediately. That is the bill, Mr. Chairman. Take any questions.
Questions for Mr. Anderson? All right. Co-chairman Case.
And Mr. Chairman, just kind of the package here. The governor's office had proposed some changes, and I think there's a draft, and it's not in bill form of that, and I hope that that's available to everybody that's interested in the audience. And I think it's posted on the website now. And so just kind of connecting all that. The governor's office harkens back to the governor penned a letter which accompanied, I don't remember whether he signed the bill or didn't sign the bill, but when the bill passed into law, the governor issued a letter about and concern that our change in the law would dampen the ability of persons that were registering for the first time to participate. And so I think that's the genesis of what, have I got that right, Josh? And appreciate that.
Yeah, I believe so, Mr. Chairman. Yeah, it was handed around to the committee, the alternative language proposed by the governor's office. And as you noted, it is also available online.
Thank you, Josh.
All right, thank you, Mr. Anderson. Secretary of State's office, do you have remarks?
You, this governor's letter, so do you mind after we have our initial remarks, if I were able to come back up once we review it?
Of course.
Thank you. Thank you, Mr. Chairman. I'm Chuck Gray, the Wyoming Secretary of State, and to my left is Joe Rubino, our Policy Director in Council. When House Enrolled Act 70, Political Party Affiliation, Declaration, and Changes, was passed and allowed to become law, our office, in conjunction with county clerks, immediately began working with our Wyoming voter registry list, WyoReg vendor, to modify our WyoReg systems to accommodate the legislation. These changes included, but were not limited to, restricting the ability of registered voters to change party affiliation within the time period between the first day of candidate filing and the date of the primary, and preventing registered electors from canceling their registration during the time period prescribed by statute, in order to fix what was identified as the cancellation loophole, in which electors who would otherwise be stopped from changing their party affiliation from simply canceling with the intent to re-register and change their party affiliation. In conjunction with the original intent of the legislation and based on our interpretation of the statute, I want to be clear that the Secretary of State's office and the county clerk's implementation and preparation would not prevent new registrants from registering and affiliating with a political party during the time period between the first day of candidate filing and the date of the primary election. Again, I want to emphasize that the technical requirements, which were set to go into production by the end of January 2024, would stop crossover voting without preventing new registrants from declaring party affiliation during that time period. To further clarify this, and in line with the discussion we had in August in Douglas and in discussion with the committee, our office recently came out with guidance to this effect with Directive 2023-01. In consultation with Wyoming's county clerks, we drafted a directive mirroring the interpretation and technical implementation of House Enrolled Act 70 as written. And again, the key section of the directive, which we sent out to the committee, is on page 2, paragraphs 3 and 4. The county clerks and the Wyoming Secretary of State's office. This goes back to our discussion with the governor's office at the time the bill had passed both houses. We've been in alignment on our interpretation on this from the beginning, and we issued this directive to further clarify that. We also provided 6 illustrations of different situations that makes clear that a new registrant would be able to register and affiliate, but an existing registrant would not after the lockout period began. I appreciate the committee adopting the amendments we presented in August, which provided further clarification to the statute without requiring further technical changes to be implemented during an election year. While I've always said further clarification in statute is fine, I believe our interpretive guidance is all that is necessary to carry out the intent of the legislation. And in my opinion, we do not need this bill because it's very clear. But I would like to review the governor's language as well and see what that does with the loophole. But our amendment did remove the cancellation loophole.
And have you at least seen the governor's amendment, or no, you haven't seen that?
No, I was not sent it. This is so if we could reserve the right to come back up, I'm going to go ahead and print it up in my office and take a
Yeah,
look.
just to be clear, Mr. Chairman, it didn't come from His Excellency directly. I had been talking with the staffers, one of the staffers, and so I don't want to pin this on the governor if there's a fault of you seeing it. I think it may have been my fault, and so let's make sure you see it and everybody sees it. So, and we have extra copies, don't we? Or is that's yours? We want to make sure you have it.
Yeah, we'll get them some copies, Mr. Chairman.
Okay.
Thank you.
All right. Sounds like a good plan. How about our Clerks Association? Any comments on this bill? No? All right. General public comment. Anyone in the audience wishing to comment on this bill, come forward. Anyone else? Come on, there's 4 seats. Just come and fill up the seats if you want to testify. Welcome back, Gail.
Gail Simmons, Civics 307. I'm a resident of Sheridan County. Mr. Chair, I just want to say that this change is an absolutely excellent clarification that was needed. It was actually a point of discussion, the impact of not having specific language. I remember it on the floor of the Senate. I don't know that I remember it on the floor of the House. So this clarification does in no way diminishes the intent of the ban on crossover voting, which it was to keep people from basically in the primary from hijinks that some people think are the overwhelming motivation and others think that people just want to vote. So I'd just like to point out that there are 3 different statuses when it comes to registration. There is registration that is active. So it's active, they're registered, they've got a party affiliation. And so this banning change in party affiliation cleanly says, no, you can't do that. You can't come in after in this case, I think 16th of May and change that and then vote in the primary. The other two are a registration that is inactive. In other words, they voted 3 years ago, didn't vote in the general, and were administratively made inactive. They have a voter ID. There's a registration in WyoReg, but it is an inactive and has been for some time. Now, is that a new registration or is that a re-registration? And that is not addressed in either the directive that I'm going to come back here in a minute or in the statute. So I think that if treated as a new registration, even because it had been inactive at that time, then I think it's fine. And the final one is the new registration where there's been no voter ID in the past. So it's really clear that this is new. And so the discussion that was made in the Senate was specifically about somebody who said, well, when their son turns 17 prior to the primary and waits until June to register, does this mean they can't? Well, the statute is not clear. So it's very clear, very specific on not changing an affiliation, but it is not clear on a brand new registration. So when I go back to this directive that was provided, I've got some concerns about the language on there in that it states in that first paragraph.
And Mr. Chairman, do we know what directive, does the public know about the directive? Maybe.
Sure, it's directive number 2023-01, interpretation of HEA 70, and it is specifically giving very clear direction to the clerks on how they are to administer based on specifically stated the Secretary of State's interpretation of that House Enrolled Act.
And so, Mr. Chairman, the directive is from the Secretary of State's
Is from the Secretary of State.
I think we received it yesterday, and I believe the clerks received it because it was something that was directed to them. But I'm not aware if the public knows what we're talking about here. So I'm just throwing that out.
Okay, so I'll specify when I'm on here. The first paragraph identifies that that 222121A1 specifies that the statute says provide written directives and instructions related to and based on the election laws. Actually, the directives was specifically stated under a subsection around emergencies. I think, but in any case, directives is fine. But then it specifically states provide uniform interpretation and guidance in the implementation. My concern here is that I don't believe that it is the Secretary of State's responsibility to interpret law. I think it is the legislative responsibility to write laws that are so clear that it doesn't require executive branch clarification. And so specifically, it talks about it references some other areas when you take an oath that you are qualified. But then basically in this directive provides from the Secretary of State, provides the specifics. And my point is it needs to be in law. A voter, back to our discussion about, is the point of the law to be for both the citizens that are impacted by the law, as well as the individuals who are responsible for enacting or administering the law? Is it for both, or is it just for those people who administer? And I say it's for both. And so the voters need to have it be very, very clear. So I ask you to please pass this statute, which provides that clarity.
Questions, committee?
And Mr. Chairman?
Yeah, please.
Ms. Simmons, have you seen the red line language that we got from the governor's office?
Mr. Chair, Senator Case, no, I have not.
Okay. We want to make sure everybody can see that. Yeah. It is online at the moment
And it's in the hallway.
and in the hallway.
I'll go get it.
Okay. We'd let you back. If she had comment on that and that became a play, we'd let her back in, right?
Okay, yep, that's fine with me.
Thanks.
Thanks, Ms. Simmons. Ma'am, you're up.
Good morning, Chairman and committee members. My name is Marissa Carpio, and I'm the Policy Director for the Quality State Policy Center. ESPC is a nonpartisan coalition-based 501c3 that aims to advance fair elections and transparent government in support of all of Wyoming's communities. We want to thank you for taking the time to discuss electoral reform. It is especially a relevant topic given the national rhetoric surrounding elections. ESPC is committed to supporting a secure, accessible, and transparent election system. Among the states, Wyoming is unique in that our Constitution protects the right to political equality. Laws that create special classes of people and provide different levels of access to certain political rights violate the intent of our Constitution and build political inequity into state statute. Our biggest concern when looking at these bill drafts is the protection of our voters. We neither oppose nor support any of these bill drafts, but wanted to bring focus to the importance of political equality when we are making decisions about our elections. Thank you again for taking time in electoral reform, and I can now stand for questions.
Questions, committee? All right, thank you for your testimony. Any additional public testimony? About online, if you're online, raise your virtual hand if you want to testify. Do we have one online?
We've got people coming up though.
Yep, I'm just getting them on deck.
Okay.
Ms. Russell, welcome back.
Thank you, Mr. Chairman. Again, Kathy Russell, Executive Director of the Wyoming Republican Party. And I will be sharing the sentiments and the decisions and discussions, things that I have heard around the counties, around the state. This crossover voting is probably the #1 issue for our people in terms of election integrity and election security. And that's why there was such widespread support for this bill when it was passed. Speaking personally, the last line, not the last line, I'm sorry, line 9 on page 2, appears to negate everything that was done in the bill. And the reason I say that is if you are not registered to vote, and I'll give you a for instance, we've been talking about for instances in the committee hearing today, so I'll give you a for instance. If you're not registered to vote, after the first day on which an application for nomination may be filed, which is roughly, what, May 5th, somewhere around in there? Under WS 22-5-209, from registering and declaring a party affiliation before or at the next primary election. That seems to allow what we were just trying to prevent, because in the primary election, we have our nomination process for the party, which is a private organization. Again, it got put on the ballot in roughly 1990, I believe it was in the 90s. And rather than voting on it in our meetings, it's now on the ballot. And that's why this is not a voter-wide issue. It is our nomination process. So let's say somebody goes into the clerk's office and says, I want to drop my registration. Then they go back in on the day before, the week before, the day of, and they say, okay, I want to re-register. And here's the party I want to be in. There is a big loophole there. So I just wanted to reiterate that this was a bill that has been a primary concern and a primary push for members of the party because they feel disenfranchised when they see, and they all have examples. As the executive director, I get the calls, I get the notes of examples where they feel disenfranchised by people who openly mock the system in the coffee shops and elsewhere. Oh yeah, I change my affiliation every year. Yes, it's anecdotal, but I can tell you that the people who are sharing this information are not treating it as fluff. Thank you, Mr. Chairman.
Senator Barlow.
Thank you, Mr. Chairman. So I guess I'd like to know, are you familiar with the Secretary of State's guidance document directive? First, that'd be my first question.
I'm not.
So thank you.
Mr. Chairman.
Thank you, Mr. Chairman. So, Ms. Russell, I think that the concern you're talking about is actually provided for in that guidance document based on current statute. So I actually to review that, I think it's would be guidance number 5, example number 5 is what you just outlined. And that is what, at least my interpretation of what the Secretary of State believes would be allowed under current statute absent this bill, So anyway, I just throw that out there because I want you and as a representative of your organization to be understanding about way current statute is going to be interpreted based on what the Secretary of State has just released. So thank you, Mr. Chairman.
Ms.
Mr.
Russell.
Chairman,
Yep, go ahead.
there was just an argument made that things need to be clear in the law and not leave it up to agencies or an office in this particular case. While I disagree with that, I would argue that there should be clarity, and this is not clear. It does offer an option to go around the statute that was passed last year. Thank you, Mr. Chairman.
Further questions for Ms. Russell? All right, thank you, Ms. Russell. Any additional public testimony in the room? All right, we'll go. Oh, you're going to come back for a second bite at the apple now?
Chomp, chomp. Gail Simmons, Civics 307. I've taken a look at this redlined, and Mr. Chair, I don't like it. I don't think it clarifies or provides any further, and it doesn't address the problem, which is excluding brand new voters. And so the last speaker talked about this gutting. Well, for this last several years, the argument has always been registered Democratic voters coming in, changing their party affiliation, voting in the Republican primary, and then changing back. So it was always currently registered people. And that boat has sailed. Everybody, the law has been changed. You cannot change party affiliation within that time frame, and nobody is looking to gut that or change that. These are brand new, and so it may be from not understanding WyoReg, but when somebody comes in to register, the clerk brings it up on the screen, and if they are already in the system, they had a prior registration. So the way your language is on 5 through 9, that would be where it comes up, and they do not have an existing registration. These are brand new. They've never voted before. They've never declared an affiliation before. It's not gutting it. It actually just allows for brand new people. They've moved to the state. They're turning 18. It's that very specific only. If you've already voted, you're in the registration system. That would be a change. This is brand new.
Co-chairman Case.
Thanks. Ms. Simmons, did you forget how to say chairman? Remember? We had a
Oh,
little discussion
I
about
probably
that.
did.
Yeah,
Sorry,
that's
Chairman.
okay. So, Ms. Simmons, just to be clear, trying to summarize it up. I think you're saying in your previous testimony that the directive that we saw kind of misses the vote. And then you're saying that this proposal from was from the governor's office is not helpful because it broadens it from the issue that we really tried to address with the bill. Yeah.
Mr. Chairman, Senator Case, the directive actually is helpful to the clerks in that, to the point that you previously made, that they're acknowledging that if you're brand new, you're not in the system and you've never voted before and never registered before, that you have a right to declare a political affiliation.
Okay.
I'm simply stating that this draft bill puts it into statute as well as in an administrative directive of the Secretary of State. The governor's doesn't address the newly registering voters at all. So this in no way guts or changes the whole intent that has been stated many times of not having people who have been registered in one party from changing over from another. It absolutely does not touch that.
Just in the final to drill it home, then the bill in this narrow form accomplishes exactly that for new registrants. It's what we're trying to do. And that was a concern expressed from the governor's office before. I'm not sure if things got translated in this effort. There may have been a sideways slide. But so your recommendation is to hang in there on the bill draft as it is with no changes. That would be what you're saying.
Mr. Chair, Senator Case, absolutely.
Okay. Mr. Chairman, Senator Case. It's okay.
Oh, I forgot the Mr. tonight.
It's okay. And I want to bring something up. There's a lot of paranoia, I guess. I saw where the major party in Wyoming sent out a directive saying that we were trying to get the whole thing and all of this. I received that warning that we needed to pile on at this committee meeting because we were going to do this dramatic change. I saw that. It came out as a directive from the Republican, from a major party. And then I also have this deal with this directive that came out. The timing of the directive, Mr. Secretary, was yesterday. And I'm like, are we just trying to stop having conversations? Can we have a conversation about a bill that's on the table? And is that okay? So Ms. Simmons, I'm grateful for your testimony and the fact that we can have a conversation and agree. I disagree with the original bill. You guys, I think people should be able to change parties all the way. But we're not messing with that. We're just dealing with the situation where there's a brand new person who needs to vote in Wyoming and they don't match up with the timeline we previously established. It doesn't do any more than that. It's not paranoid. And I get really annoyed when people aren't helpful because this is the most hardworking committee that tries very hard to get these laws right. And so that's my tirade, and I used her to do that. Thank you.
Mr. Chairman, Senator Case, I think I got it right that time. The fact remains that almost 50% of eligible Wyoming citizens are not registered to vote. And of those who are registered, up to 35% do not vote in a primary. That is almost exclusively those in the largest major party. We don't have a problem with fraud We have a problem with participation. So anything that clarifies and encourages qualified individuals to exercise their franchise, particularly those who are brand new, I think is always to the good.
Thank you, Ms. Simmons. Just wanted to offer a clarification to the virtual world. We've had some folks sign up late to try to testify on topics. Our rules provide that the cutoff is 5 p.m. the day before. So it gets a little tricky with our online format because the link is still open to register, but that's for registering for tomorrow's testimony. So I just wanted to offer that clarification to the virtual world. If you're out there and you're watching and you're listening to us, if you did not register by 5 o'clock yesterday, you cannot testify on anything today. You can register now to testify on something tomorrow, but not today. So I just wanted to offer that clarification. With that being said, do we have any virtual testimony? It's Mark. All right, welcome
Yes.
back.
Thank you, Mr. Chairman. Mark Kapp, I'm a resident of Sundance, Wyoming and Crook County. Before I give my testimony, I just need to verify, are we looking at Bill 24 LSO-0098 Working Draft 0.5?
Yes, that is correct.
Okay, because I was confused after the previous comment, because when I read this bill, it specifically is changing the existing law. In fact, there's no clarification in it at all. It's very vague. For a primary election, a qualified elector may declare or change party affiliation on an existing voter registration by completing an application. That doesn't say somebody who's new and just moved here can change their party affiliation. In fact, the reason I'm here is I am opposed to this bill as it exists. I don't think you should move it through this committee at all. I think it should just be eliminated because it is openly changing the existing law. And so I went back in time. And the reason why people are so hot about this issue is I'll reference Politico, an article from 8/18/2022 from Madison Fernandez, specifically saying Democrats switched party registration in Wyoming. It couldn't save Cheney. From January 1st, 2022 to August 16th primary, there was a 20% drop in Democrat voters while Republican voters jumped 10%. Now, stuff like that, that's articles that are out there. That's the reason why this bill was pushed and passed in the last term. And that's why folks like us are opposed to any changes to that existing bill. Now, I do have challenges when executive branches provide guidance, but I trust Secretary of State that the guidance has been gone through with the clerk's office. And as this bill is written, I don't see anybody in the state who could read it and interpret it anything other than a broad change to the existing law. And so with that, I oppose this bill, and I'll stand for any questions.
Questions, committee? Senator Barlow.
Thank you, Mr. Chairman. And again, I would ask folks who are interested in seeing what the Secretary of State's, and I looked online, I don't see it online yet, but I'm sure it'll be posted at some point.
It's up. You
Okay,
might just
maybe
have
it
to
is up.
refresh.
Thank you. It's up. I think what the interpretation the Secretary of State's office is taking on some of this is exactly what this bill draft provides. Whether it's necessary or not, that's a different question. And that's, I think, what the Secretary of State came forward and said, look, we get what you're trying to say with this bill. We'll handle it in another way. So for all those folks who are concerned about this bill draft, maybe take a look at the actual guidance first, and then maybe you'll have something else to be concerned about. Thank you, Mr. Chairman.
Thank you, Senator. Secretary Gray, welcome back.
Thank you. Well, thank you, Mr. Chairman, for providing this opportunity. We have reviewed it's a little unclear, I guess it was the governor's staff or the AG or somebody's language in the governor's sphere, the language that they've sent to the committee. I want to clarify a couple things here and go back in time. Really appreciate Senator Barlow's comments. So in August, we had a bill draft that was before us that went backwards on our crossover bill in a major way. It removed the cancellation loophole, which again is that after the beginning of the cutoff, which is more or less May 15th, the day before the beginning of the filing period, more or less May 15th, an individual cannot cancel their registration which would then allow them to change their party affiliation in existing registrant. So we came in, we testified that this is not the intent of what our conversation, the day the governor had to make the decision on whether to allow the bill to become law or sign the bill or veto it, this was not what we had talked about in adjusting this statute. And this is my concern about going back and doing this again, is we have this language which we haven't really had time to evaluate that does something entirely different from what our conversation was with the Senate once this issue was identified earlier this year, and with the governor's office in that meeting. All that the governor's office said was, we want qualified before the word elector twice in statute. That's basically what their issue was. And we said it's not necessary. Qualified elector and elector is used interchangeably in statute throughout Title 22. And if that's their interpretation, we told them, you're going to make 10 to 15 statutes inoperable if you're not going to acknowledge that they're interchangeable. That being said, there was an understanding that maybe we try to put qualified in front of elector in a couple different places. But I really don't think that addresses the issue here. I think there's some that maybe, I don't want to get in people's head or searching for a problem, but it works. And the county clerks and I have been on the same page on this from February 1st forward when this was first identified. Now, I do want to respond a little bit to the Chairman Case's comment because I don't think he intended this, but I think there was maybe some might insinuate some question on motive on the directive. We were clear in August. In fact, one of the conversations we had in moving this bill to the next meeting as opposed to taking action was that it would provide us time to issue a formal directive. And we've been talking to the clerks about the wording of this for about a month. We had a little bit of a conversation last week on a couple changes we wanted to make, so we made those. And yeah, we formally issued it 2 days ago. But this has been an over a month-long process with the clerks, and we've been on the same page about the interpretation of the statute since mid-February, early February, when this issue suddenly came up in the Senate after it passed the House 47-12 or whatever it was, somewhere in that line, and it came directly to the floor. But this is why I don't think we should bring the bill, because we're just going down this road of it works. We're all on the same page. We've always been on the same page. I suppose we could put qualified before elector once or twice in statute. But if the interpretation is that you need qualified before elector, Title 22 has major issues with it, because there are other places where you're supposed to have qualified before elector where it is not presently there. So I think it works. Directives are clearly allowed. There's precedent for it. We were just going through the folder. They're done every single election cycle. There are directives. So I just think that, and it's clearly allowed. So, and we lay that out in the guidance at the start. All the references where we're allowed to do that for clarity. So thank you,
Mr. Chairman.
Go Chairman Case.
Thank you, Mr. Chairman. Thank you, Mr. Secretary. I don't detect that there's anybody wishing to take up this red line proposal that we received from the governor's office. But I had been in communication with the governor's staffer, and we got this couple 3 days ago, I think. And so I said, well, let's have it prepared as an amendment to discuss it. And so that's the source of this. It's okay to have that conversation. I think you did a very good job of addressing it. Absolutely. What it felt like to me about the directive, and when the Republican Party, the majority party says, don't touch this bill, we can't, they're trying to rip the guts out of it. I'm just trying to have a conversation about it to fix what I view as a potential problem. And I'm persuaded the last witness from Sundance, I think people are seeing things that go bump in the night here, Mr. Secretary. Maybe you're doing a little bit of it yourself, because I don't see that as opening it all up because of the language that says on an existing voter registration at the beginning of the paragraph. I think I'm reassured by that. Ms. Simmons' testimony was persuasive to me. So because of it saying on an existing voter registration, that means that you can't be a change situation. We're talking about wholly new ones. So anyway, that's where I'm at, Mr. Secretary. And it'd be helpful if we communicated more for sure. And
Well, I appreciate that, Mr. Chairman.
Yeah.
Mr.
and always,
Secretary.
thank you, Mr. Chairman. I always enjoyed working with the committee and working with you. We don't always agree, but that's okay. I guess where my concern is, and I understand your argument, the way it currently reads, but my concern is the way it previously read, just constantly. I mean, it goes back to our meeting with them when the day the decision had to be made, their argument changed within the meeting, in my opinion. And I understand they won't, and now we've got this other iteration. I mean, it's just constantly changing the language. And my concern is you have a draft that goes back. I mean, Clerk Irvin came up with closing that cancellation loophole. My understanding, that's the statutory history on that back in 20 or 21, which was the fifth iteration of crossover since I've been here. I don't know how many times it was done pre-2017. And I just think it works. I mean, it goes back to the testimony earlier, is the juice worth the squeeze? I don't see, is it worth us for us to go down potential other draftings that may come out when it is very clear as it is right now? And I think we need to let this work, and we've all been in agreement on it. So that's my argument. But I understand what the chairman's saying.
Co-Chairman Case.
it's clear about the change, but it's not clear that we're going to allow someone that's new to vote. It's not clear to me. You know, and if you disagree, fine. That's not clear to me by the existing language. It's clear in your directive because you tell them to. But this language doesn't say, if you're coming to Wyoming or you've never registered before, irregardless of these deadlines, you can register. That's not clear to me. Maybe I'm just missing it. But that's the only part I'm trying to deal with. I'm not trying to create a back loophole where you can unaffiliate and come back in. I wish I could, I honestly do, but I am not trying to do that. And we have to accept each other's integrity at some level by our oath and our commitment to each other, executive to legislative and citizen to citizen.
Yeah, well, Mr. Chairman, certainly understand what you're saying. I disagree with you, and I know we're going back and forth on this, just my opinion. I think it is clear in the statute. I think it becomes further clear when you read Title 22 in its entirety. And just to clear it up further, we issued the directive in line with our discussion with you in August and in line with our discussions with the governor going back to our 11th hour meeting the day he needed to make the decision. But, you know, I am concerned about the changing arguments as to what we're doing with this. I mean, it goes back to the what came in the second meeting, and I'm not saying there's any bad intent, but there was the removal of the cancellation loophole there. And then even with the governor's comments, this is totally different from the qualified before elector discussion that we've had with them. So that's my concern. But thank you.
Co-Chairman Case.
Thank you, Mr. Chairman. You definitely have my commitment. I wasn't party to some of these other things that you're talking about. I'm just trying to deal in the world that I'm aware of. So I don't believe I know about the second meeting or what discussions have had between executive people. So thank you, Mr. Secretary. Thank you very much. You may not be off the hook. I'm not sure if anybody else has something.
I think you're off the hook. Ms. Herman?
Thank you, Mr. Chairman. Marguerite Herman here from the League of Women Voters. Just to clarify, I think one thing that has been confusing to cause what has been termed paranoia is, just to clarify for anyone who's listening, that the paragraph with addressing the existing, the qualified, the existing person changing, if you read the rest of that is not in red, existing statute, new statute, it talks about that applies only before the first day on which an application for nomination may be filed. In other words, it simply puts a fine point on the current blackout period. And I think people are not reading that, they don't understand, or that it's confusing. And I think that's causing unnecessary consternation, that it's referring to the entire period right up to the primary day, and it's not. It's still, that blackout period is still there, which is, you know, I'm not in favor of that, but it's law now. And so I think that I'm not sure why it was anyone wanted to put qualified elector in there, but it does no harm. It does not change the bill, does not change anyone's ability to vote. I mean, to change a registration during the blackout period. And I think if anything to make that really clear, that that is intact completely, and that this refers only to brand new registration. So nothing is gutted. So I think people read the red type there and then assume that that's referring to the entire primary election season, and it does not. It refers to pre-primary, which is what the intent of the bill was, the new law, and it's preserved in this. So I don't know if that helps maybe allay some fears about changing the underlying premise of the bill, or the new law. Thank you.
Questions for Ms. Herman? All right, thank you. Any additional public testimony? Seeing none, I will close public testimony. Committee, what is your pleasure? It's been moved by Co-Chairman Case and seconded by Representative Chadwick. Yep, Senator Boner.
Thank you, Mr. Chairman. On and against the bill. In this discussion, I think we need to acknowledge first and foremost that this does have a very controversial history to it, this concept. There has been lots of concerted effort over the years, and it took a long time to get this passed into law. And I have to say, I learned some very creative ways for a bill to die, watching the various iterations of this piece of legislation fail throughout the years. And so I think there is a general lack of trust, not not making a comment on any one legislator or secretary of state or whatever, but there's a general lack of trust out there because this is still very fresh in people's minds. I think we have to acknowledge that general context. Furthermore, I think we all acknowledge that, and we made sure this was very clear in the Senate, between the clerks, Secretary of State's office, we all agree that if you are coming of age to vote during this blackout period, you can vote. That is crystal clear. What we're trying to do here is ensure that 20 years from now, it's also clear. I think the Secretary of State's action, I commend him for taking action to clarify, that provides some stability. But the reality is we have several years to fine tune the statute. If that becomes necessary at a later point, I'm not necessarily opposed to doing that, but I'm just acknowledging the recent history of this effort. And I think it's just going to be it's nice to have. It's not necessary for a budget session, especially. And I think that we have some assurances of clarity between the Secretary of State's office and the clerks. I just don't think this is the right time for a bill such as this. So I'll be voting against it.
Okay, before we jump into more comments, I just want to ask if there's any amendments right now on the bill. And if there are none, then we can discuss it. Okay, Co-Chairman Case.
Mr. Chairman, I would entertain, if it made people feel better, to remove the word qualified in 11, but I'm not offering that amendment. I'm just throwing it out there. If that's where the boogeyman is, I don't know where the boogeyman is. We are on the eve of an election. 2024 election will be here. We're not going to have a session in between. So if we can clarify our law, this is the time that we have to do it. We have an obligation to do that. This does not allow changes in party affiliation. It does not create a loophole. There are two sentences in the paragraph, and the first one says that for a primary election, a qualified elector may declare or change party affiliation on an existing voter registration. And I might add that unaffiliating is a change. By completing an application signed before a notarial officer or election official and filing with the county clerk before the first day on which the application for nomination may be filed under WS 225209. That says what they can do to change before the blackout date. That's clear. But then the next sentence is saying, hey, if you're not registered, you get to participate. That's what it says. Nothing in this subsection, and it's specific to subsection, shall prohibit an elector who is not registered to vote in Wyoming after the first day, after the blackout period begins. They're not registered. After the first day on which an application for nomination may be filed under the same statute, from registering and declaring a party affiliation before or at the next primary election. Two separate standalone things. The only time you can change your party affiliation is before the blackout period. If you've never been registered before, or you're not registered, you get to do it after the blackout period, but that's the only exception. That's what this bill does. It's very clear. And it's a good change. My constituents don't go and read Secretary of State directives. I'm sorry, they don't. Or the bill.
Representative Haroldson.
Thank you, Mr. Chairman. So obviously, we've had this discussion many times before. Last year, legislation, one of the things that came forward was the concern in Title 22 about elector, qualified elector, and the discrepancies that we saw. And so that was the conversation we had with the executive branch, with the governor's office, saying that's something that at some point in time we need to clean up. And I said, I'd be a part of that. I'll be a part of cleaning that up. We don't do that in this, if we're being 100% honest. So this is the deal. We have a directive by the Secretary of State that's going to make it that this next election, we have an election that someone who has never registered can register in the blackout period. We have that before us. We could pass this. We could move this through. We will have to come back to Title 22 and fix this at some point in time, you guys. This is beyond just this conversation to the fact that we have a discrepancy because we don't have clarity. I mean, we had bona fide resident and resident. Well, okay, so we get it. Bona fide is real. It exists. But what we have in qualified elector and elector is not clear, and it needs to be fixed. And so I question are we actually accomplishing what we're trying to accomplish here? And it could be a situation, sure, we could pass this and try to make that change. That change is large. That change is taking and opening up 22 to fix a discrepancy that has been found. And so I am still very much in support of fixing a discrepancy, but this doesn't do it. This is just fixing a very small sliver of a much larger picture. Now, do we do that and walk it through? That's a decision that this committee is going to have to make. But the thing that I will very much warn us on, we will be back. And is it a situation where we allow the directive to go through an election cycle, get into a general session where we can then say, hey, let's take a look at 22 and elector, qualified elector, and let's fix something. That's where I'm at. So today, I believe on this bill, I'm against this bill, not so much that I disagree that what we have coming before us came from the Secretary of State's office. But the reality is it doesn't fix the elector, qualified elector, which is what I gave my word that I'd help fix. And I will help fix that. I will help be a part of that. But I don't believe this does that.
Additional discussion. All right. Let's do a roll call vote on 24 LSO 0098 political party affiliation declaration and changes.
Mr. Chairman, for roll call, Senator Barlow.
No.
Senator Boner. Senator Landon excused. Senator Scott.
Aye.
Representative Chadwick. Representative Haroldson.
No.
Representative Harshman.
Aye.
Representative Knapp.
No.
Representative Newsom. Representative Ottman. Representative Wiley. Representative Yin,
Let's come back to him, see if he comes back to the room.
Co-Chairman Case,
Aye.
Co-Chairman Olson,
No. Give us 1 second. Let's just see if
Yeah,
Representative Yin is out.
It's okay. It won't change the outcome of the count, but if he wants to register a vote, why don't we leave it open? It doesn't do any harm. It's not a trickery. It doesn't hurt.
Here
He
he
can vote
is.
one way or the other. He's heard the testimony.
I,
There you go.
all right.
Representative Yin, aye. 6 aye, 7 no, 1 excused.
I'm thinking lunch.
Yep, so committee, we have 3 more bills on elections, but we also, oh, what was the count of the vote?
7-6. 7
Seven, 7 no, the bill has not been adopted by this committee. We have 3 more elections bills, but we also have an afternoon of elections. So we will go ahead and break for lunch. We'll be back at 1:30 and we'll continue our discussion on elections.
Hooray.